Good morning, ladies and gentlemen. I hope our dear President of ULS is around. We are just waiting for her such that she opens this session and then we can start. Thank you. Good morning once again, ladies and gentlemen. I'll switch on my video much as my internet is breaking for such that everyone can see who's speaking. My name is Muhereza Nicholas. I'm a lawyer and a petroleum and mining expert, lecturer of law at Uganda Christian University, Institute of Petroleum Studies. I just wanted to take this wonderful opportunity to welcome our dear President, Council Fiona Wall, to kindly open this session for us to be able to begin. And I want to send my sincere apologies to everyone who's attending this session for the delays and the technical glitches that we had. So I hope we can have a wonderful morning session. I'll be the moderator of the morning session. Thank you so much. So, Madam President, I'm very well aware that you have joined us. Kindly please open the session, and then we shall have Council Oluka from Muema and the company advocates take us on with the topic of intellectual property and local content. Thank you so much, Madam President. You are very welcome.
Good morning, Nicholas. Thank you very much. The panelists, council members present of the ULS, Our esteemed guests, ladies and gentlemen, good morning. I'd like to welcome you to this oil and gas webinar. As you all know, much as we've had COVID-19 disrupting us, we've also had a few good things happening for Uganda in this season. And one of them is really the coming to realization of our oil and gas aspirations as a country since the 1900s. I'd like to thank the team that has organized this. I'd like to thank our oil and gas cluster and natural resources cluster. I'd also like to say that I want to thank everybody that has signed in. It's good for us to build our capacity as a country. As you heard or might have seen, we met the president and we spoke about the issue of ring fencing oil and gas activities, especially legal services, not just to keep them here, but to also make sure that lawyers in Uganda have a say on even any foreign experts that might be recruited. We think that countries like Nigeria had to take so many years to get here, and we've seen the pain that people suffered. So we need to do better. We need to learn from our neighbors. We need to learn from Botswana. Today, I'm looking forward to hearing about benchmarks, best practices, where it has worked, how we can make it work in Uganda. As I'm always saying, most countries that seem to win in these negotiations lead with their lawyers. So as lawyers, we need to be experts, we need to be aware, we need to be current with what is going on so that we can advise our clients, we can advise the government, we can advise the general public. For those of you that are not aware, we are concerned about environmental issues as well in the Uganda Law Society. I hope this will be discussed. And I'm hoping that even as we have these deliberations, any issues that come out as tasks for the Law Society, I bring you greetings from the council, and I'm hoping that I will be able to pass these other requests on. The CEO is present, so if you should have any requests for ULS regarding oil and gas and how to make it better, we will be present. Thank you very much, and have a good morning. I'd like to declare this workshop open.
Thank you so much, our dear President of Uganda Law Society. Thank you for the wonderful remarks this wonderful morning. Our dear distinguished Uganda Law Society members on this particular Zoom meeting this morning, we want to welcome you and thank you for participating in the activities of the Uganda Law Society. For me, it's a humbling pleasure and really a privilege to be moderating this morning session. Without wasting a lot of time, I wish to invite counsel from Mueman Company Advocates Council, Andrew Oluka. You are very much welcome, sir, and please take us on with the topic intellectual property rights protection as an enabler to local content in oil and gas sector. Thank you so much. You are very much welcome, counsel.
Thank you very much, Nicholas. I hope I'm being heard.
Very loud and clear.
Thank you very much. Thank you for the invitation to come and share with colleagues who are present on intellectual property rights protection as an enabler to the growth of local content. I am going to be very brief with my presentation, which is really intended to jog our minds and cast our eyes towards intellectual property as one of the tenets that we can use to grow our local content. I'm going to try and share my slides. Hopefully we can see them. Nicholas, would you please kindly confirm if we can see my slides?
Very wonderful slides. Yes, we can see them.
All right, thank you very much. So the topic of discussion that I'm presenting on is intellectual property rights protection as an enabler to the growth of local content. This is how I intend to handle that topic. I'll give a brief introduction. I'll also highlight some of the current IPR protection regimes. Then I will shed some light on how IPR can stimulate the growth of local content. I'll handle some of the challenges that we are faced with in protecting IPRs. I'll make some brief recommendations, and then I will draw a conclusion. But of course, you're free to draw your own conclusion. So let's dive into it quickly. We all remember that in 2006, the president gladly announced the discovery of commercially viable oil reserves in the Albertine Graben. This discovery was greeted with a lot of optimism amongst all of us as Ugandans who anticipated the benefits that are associated with being a petroleum exporter and a producer. This ushered in a number of things. First and foremost, in 2008, the country put in place a national content policy, which was intended really to guide the exploration, development, and production of the resource. This policy was followed by enactment of various legislations. Key among those legislation is the Petroleum Exploration, Development, and Production Act of 2013. The important thing to note in all these legislations is that they provide sections that ring fence the provision of goods and services to Ugandans or Ugandan entities. And this is really local content, because if you make laws that restrict certain activities to the locals, that means you're growing your local content and you're encouraging participation of the locals in the sector. So when you look at the various legislations that have been put in place to regulate the oil and gas sector, many of them, actually all of them, do have clauses that ring fence provisions of goods and services to Ugandans or Ugandan entities. Some of these goods and services include transportation, include legal services. As lawyers, we are very interested in this and concerned about this. And so this is really to encourage our participation as Ugandans in the sector. And this is a very good thing, because that's the only way as a country we can avoid what is commonly known as the resource curse, by ensuring that some of the proceeds of the sector are shared locally. So I'll move to the current IP regimes in the country, and I'm going to restrict myself to three, which I think are very, very important to the oil and gas sector. The first is the Trademarks Act, which affords a trademark owner protection over use of the registered mark. We are all, I want to believe we are all familiar with the Trademarks Act of 2010 and the kind of protection that it provides to trademark owners. The Copyright and Neighboring Rights Act of 2006, which protects literary works, scientific and artistic works. One might ask what literary works or scientific works are associated with the oil and gas industry. Geographical studies, for instance, are things that can be copyrighted. The data you collect, the books we shall write in respect of the oil and gas sector, the compositions, the literary compositions, the musical works, the artistic works, are all things that can be copyrighted and protected under the Copyright and Neighboring Act. And these are ancillary services that are related to the oil and gas sector. We might not be able to copyright the color of our oil, but at least we can copyright ancillary services that are related to the sector. Of course, the Industrial Properties Act 2014, this one for me is of particular interest in light of technological transfer, because once we fully start to explore and exploit the resource, then there will be a lot of technological transfer that comes down, especially from the IOCs. And when you look at the Industrial Properties Act, it seeks to actually promote technological transfer and utility models, designs, industrial designs, and the likes. So if you ask me, I think we have the requisite legal regimes to promote IP as a country and to relate this IP to the oil and gas sector. Nicholas, how am I doing in terms of time? I don't want to overshoot. Hello, Nicholas. Okay, Nicholas is not hearing me. So how can IP protection enable the growth of local content?
Council, please go ahead.
First of all, we have
5 minutes, please.
Pardon?
You have like 25 minutes. Please go ahead.
Thank you very much, Nicholas. So I'm looking at IP as an enabler to the growth of local content. And this is how I think IP will enable growth of local content. For example, for starters, IP will help promote brand identification. We all know that it's very, I mean, we all love to shop and buy brands. Now, if a brand is clearly identifiable, for instance, if you picked this Renzori mineral water bottle that I have next to me here, you can clearly see, and from afar, you can clearly identify that this is a Renzori mineral water bottle, and if that's what you're interested in, then you go for it. So IP, and when you look at this bottle, you'll identify a number of IPRs. For example, the branding, we have the shape and size of the bottle. All these are IPR protected issues, and which can help brand identification. So if you are a local supplier to the oil and gas sector, you want your brand to be distinctive and clear to everyone, to easily identify. And the only way you can do that is to protect its IPR. IP will also promote technological transfer. I know you know that once the resource is fully, once we fully start to exploit the resource, we'll have a lot of machinery coming in, we'll have a lot of technology coming in, and all these things. And these are protected in form of patents, in form of industrial designs, in form of copyrights, in form of trademarks. And within the country, we have the requisite legislation to protect this. And of course, as a local supplier who's seeking to develop local content, it's prudent that you also protect your own products. For example, if you have an innovation on, let's say, how to weld a certain joint, you could protect it, you could patent it. Okay. If you have data that is important for exploration, that is something that you can copyright, and that helps to grow and stimulate local content. IP will promote, IP protection will promote consumer confidence in your product. If the consumers are sure of your product and you've taken time to protect it, you've taken time to market it to the consumers, then the consumers become confident of your product. I know many of us will easily gravitate, for example, towards a Nike apparel because it's a well-known brand and consumers easily relate to it. IP will also encourage things like franchising. Franchising for me is very, very important in terms of when you look at the laws that promote local content. One of the ways that foreign companies can participate in the supply of goods and services is by entering into joint venture agreements with local entities. Now, if you have a prominent brand here and a foreign entity is interested in supplying, let's say, a similar good or something like that, it becomes easy for you to franchise and market these two products hand in hand, an international good alongside a locally produced good. So franchising is one of the things that can be promoted through IPR protection. IPR protection will also encourage foreign direct investments, FDIs. If again, the oil and gas sector is going to attract a lot of foreign interests into the country. And of course, these foreign interests will come with investments. Foreign companies, international oil companies will be interested in investing in not just the production of the crude, but also in ancillary services like provision of, let's say, repair works, provision of maintenance works and things like that. So if you, and this is something that Ugandans can position to attract this kind of investment, to be easier to enter a joint venture agreement with, for example, Lafarge for provision of cement that is needed for construction of the riggers, the roads and things like that. It will be easy to enter to attract such investment if you quote and portray yourself as a well-established institution whose brands are well known. Intellectual property rights protection will also encourage investment in research. Of course, we all know that intellectual property is as a result of innovations and coming up with novel ideas. So if people see that IPR actually does protect their innovation, their creations, then people will be encouraged to research more and come up with even better innovation. So I think intellectual property will also promote investment in research, which again will enhance our local content and our ability to provide goods and services to the sector. Intellectual property protection will help fight the vice that is counterfeit. Knowing that Uganda is predominantly an import-based economy, one of the things we're faced with is counterfeits. Now, without robust intellectual property rights protection, then the market will be flooded, with a lot of counterfeit goods and services, which in the end will harm even those genuine goods and services that are being promoted by or provided by the local businessman. So IPR protection should be able to help someone fight counterfeit. That is the only way you can assert your right as an IPR owner if you've protected it, and the protection will start by registration. Let me move to my next slide. My next slide is talking about the challenges that are facing IPR protection. So of course, we know that it's not been all rosy, despite the fact that we have various legislations for offering protection to the various IPRs. There are challenges that are facing this protection. First and foremost is the perception by most Ugandans that IPR registration is costly. This comes in terms of the function. Many customers, many clients that I've interacted with and have tried to, who have engaged me in terms of IPR protection, think that the legal charges are high, and because it's also an intangible good, so someone cannot easily see what they're investing into, and yet as a lawyer, you're telling them it's important. So there's a perception by the market out there that IPR registration is costly. Maybe this is a cue to us as lawyers to find out, to figure out how to balance the perception of the customers that the IPR registration is costly and the fact that it's necessary. There is ignorance by most brand owners as to the benefits of IPR. When you try and convince a brand owner that you need to protect this brand, you need to intellectually protect this brand, many of them are very ignorant as to the benefits that come with IPR protection, because it's not as easy as picking this phone and putting it on the shelf and selling it, and then you do your numbers and know how much you've earned out of it. So there's that challenge. Poor enforcement mechanism is another thing that is hampering IPR protection. What do I mean here? For instance, as a country, we still don't have an institution that is primarily charged with enforcement of IPR rights, because URSB does the registration. Uganda Police probably has no clue as to what IPR is all about. So the task to protect and enforce IPR is solely left to the brand owner. Some of these brand owners might not have the requisite financial capacity to do the enforcement. So you see there's a gap there in terms of enforcement, and this has boosted the counterfeit industry, because counterfeiters get away with faking or imitating registered brands. If you're a consumer of bottled water, many of us have this habit of checking under to see if there is a second sealing at the bottom to ensure just to see if there's a second sealing at the bottom to be sure that what you're consuming has not been refilled, has not been repackaged. This is all an enforcement issue which is hindering IPR. Of course, there's the lack of, for me, and this is the bigger picture, the lack of a clear national IPR policy. As a nation, we still don't have a clear IPR policy. We have policies on so many things, including local content, but IPR as a business tool that can develop and grow business in Uganda, we still do not have a clear IPR policy. I know that there has been one in the works. I don't know, I'm yet to find out how far that has gone. And if someone has information as to how far that has gone, I'm interested. I'm extremely interested in that. Of course, some brand owners believe IPR registration is time consuming, especially when you tell them you have to gazette for 60 days. Someone thinks, okay, why am I giving you my money and then I have to wait for a whole 90 or so days before I can get a certificate of registration? Of course, like as I earlier stated, Uganda is an import-based economy. So many people, many businessmen prefer to go out there, pick whatever they can get, whether it's a knockoff, whether it's a counterfeit, and bring and dump into the market. And this discourages innovation, production locally, and stuff like that, which eventually affects intellectual property. There are information gaps, especially because a lot of the information on IPR is in English, and we know that a large majority of the people are not easily relatable to English and things like that. So again, this presents a challenge. It would be important, for instance, to translate some of the IPR laws into local dialects for easy consumption and appreciation of the masses. Take an example of the artists you find drawing pictures by the roadside. Now, such a guy would probably not understand that that picture could be copyrighted and it could be worth more than just the 5,000 shillings that someone is going to pay by the roadside and make out with his innovation or his artistic works. So there's also that the gap in information gap. Of course, the influx of counterfeit goods and knockoffs because of us being a majorly import-based economy is another issue. Then there is the unprecedented surge of online shopping, which has ushered in faceless traders. Today, it's very easy and convenient for you to sit like I'm seated behind my desk here and order something online. I have no ways of verifying its quality. I have no ways of verifying its a fitness for purpose and things like that. But just because it's easy and convenient, many of us are gravitating towards online shopping. But online shopping is also very difficult to police. For instance, as a country, we don't have legislation that can hold someone culpable for trading, let's say, counterfeit goods online. And Uganda is not unique in this area because world over, the world is still trying to come to terms with the surge in online shopping and marketing. So this is another challenge that is facing IPR protection. So finally, let me make some recommendations towards IPR protection. It's important for us as a nation to promote regulations and protection of IPR rights. This can only be done through intensive sensitization of the consumer so that they fully understand and appreciate what IPR seeks to protect and what IPR seeks to promote. This way, it will encourage many innovators, many inventions, generally it will encourage local content. There is also need to develop a clear national intellectual property policy. I can't stop singing that song. I think it's important. We have so many policies, but we need to find one that is clear-cut on IPR because world over, IPR is probably one of the most traded items now. And of course, we need to align our legislations to the ever-changing faces of trade, especially with the growing reliance on ICT. I stated earlier that ICT has ushered in a large number of faceless traders. Online shopping is the way to go today. You can almost get anything you want online. Now, if we don't have ways and laws of policing this online space, then we expose ourselves to largely poor quality goods, but also we kill innovation locally, because why would I go and buy something fabricated and manufactured in Katwe when I can order a better looking version, irrespective of its quality, from while seated behind my desk? So you find that it's necessary to align our legislations to counter the fast growing phases of trade. Okay, ladies and gentlemen, in conclusion, I will find that there's still need for promotion of IPR implementation and enforcement. I believe that with the oil and gas activities set to intensify, there will be the need for a robust IPR regime can't be overstated. I hope with those brief remarks, I have been able to jog our minds and channel us towards looking at IPR protection as an enabler to the growth of local content, especially in the oil and gas sector, where we are going to have an influx of foreign technology, foreign IPRs, and foreign traders. Thank you very much.
Thank you so much, Council, for that elaborate discussion on IP and local content. Definitely, as lawyers, I'm sure we are all interested in ensuring that we take advantage of this wonderful oil and gas sector regarding the massive investment that has been ushered in, especially after the signing of the host government agreements. I'm sure we all remember when the president of Tanzania was here, and His Excellency the President also went to Tanzania to finalize, some of the legalese that were supposed to usher in the massive investments. So there is a beehive of activities that is now taking place, and I think, Council, you are very well. You are really at it very well. You enabled, I'm sure, the members to come in and understand some of the nitty-gritties between intellectual property. But for me, what I was able to catch, Council Luka, was the essence of ensuring that we avoid counterfeit through IP. And if we are to relate that with the high standards that are needed for the oil and gas sector, I'm sure it is very, very relevant.
That's very true, Nicholas.
Yeah. And Council, I would also want us to maybe also address our minds to the current IP policy. As you are concluding, you talked about developing a robust national intellectual property policy. There is one I've been able to look at, would maybe all of us wish to look at it, which was, I think, passed in 2019. I'm sure it might need some revision as recommended by you, Council. That is something maybe members would also want to press their minds on. But I would also wish to have maybe like 10 minutes for Q&A. If there is any questions from the members, we are very grateful for the members that have been able to sign in. I can see we are over 60 members present. Council is here. Council Luka will be able to answer a few questions. If you have, please, if you can please jot them down in the chat room, or if there is a provision of raising your hand and then you unmute and be able to kindly send in your questions or any submissions, additions, or queries. Please go ahead, ladies and gentlemen. Thank you. If you have any questions, please. We still have like 10 minutes to conclude our session. 10 or so minutes, much as we began late. You could please raise your hand and the admin should be able to allow you to speak. Thank you.
Nicholas, no questions.
Now let us check in the chat room. I see there is like a comment or something. Okay. Nicholas Cheswa is only appreciating members. If there are no questions, then sure, we definitely are within our time limits. Anyone with a question, ladies and gentlemen? Someone trying to speak?
No, they
I
usually
think
say when
there is someone who made a statement.
okay, someone is commenting that there will be questions during Q&A. There are questions at Q&A
Later,
okay.
Right?
Now, when you I when you open the Q&A,
Yeah, I have opened the Q&A and there is only one comment from Council Andrew Kabombo, who's saying the national policy of 2019 is available on the URSP website.
Thank you very much, Andrew, for that information.
I think that is it. If there are no further questions, then we want to take this opportunity to thank our president who has managed to open for us the session. And of course, to you, Council, Andrew Oluka from Moeman Company Advocates. We appreciate you, sir. Thank you so much
Thank
for
you
giving
too
us your time and your knowledge.
Thank you too for having me over.
It's a pleasure. Thank
Yes.
you.
Thank
All
you
right,
very much.
then I'm sure members are free to vanquish if they wish. So, but they can also take on this discussion to the official online channels of the Uganda Law Society, or you can even get in touch with the Council, Andrew Luka, or even myself, if there is any issue you feel you should need to be discussed or addressed by colleagues. We shall be definitely humble to come in and see how to develop our nascent oil and gas sector. Thank you so much, ladies and gentlemen.
Okay, I guess you would want us to start now. Can I start or should I wait for further instructions? Moderator?
Hello, Mr. Lubogo, most welcome.
Yes, yes, moderator.
The head for professional development and members affairs. I think moderator has just left offline shortly. But
Your
yes,
network is breaking. Your network is breaking.
Hello. Yes, Mr. Lubogo, good morning. Am I clear now? Hello?
I think Mr. Lubogo, you can proceed with your presentation.
Good morning, Mr. Lubogo. Most welcome for our CLE training. Dear members, thank you so much for joining. Our next facilitator is here, and yes, Mr. Lubogo, you can take, the floor is yours.
Okay, can you hear me now? I hope that, yes?
Yes, we can hear you loud and clear.
Oh, much better. Thank you. My apologies. I think the problem was the network. Network is a problem these days. But for starters, I think my discussion is in respect to a legal analysis of the need to legislate gas emissions in Uganda's oil and gas industry today. I hope, Mr. Moderator, it's okay with you if I proceed, or you want me to move at your pace. I am kind of concerned about the network challenges that we keep having left, right, and center. But albeit that, I'll be able to share perhaps a more detailed document for purposes of, your appraisal. Perhaps even better, then I'll maybe share the book, the just coming out book of the oil and gas law in Uganda. But I'll be guided by your response, moderator. So I'm waiting for your instructions.
Kindly proceed, Mr. Lubogo.
Thank you so much. So ideally, one thing we need to understand from the word go is initially there was one provision that especially provided for natural gas. And this provision was basically Article 18.7 of the United Model, the PSA, that I think most of you probably are aware now. Although this was not exactly a law, but a contract that can only bind those who are involved in terms of, the relationship, if you like. We can argue that this is sufficient in a way to safeguard the environment from emissions, provided it does not envisage how these emissions were actually supposed to be mitigated. And perhaps that left a lot of lacuna, if you like. And maybe that's what brought about the transformation through climate change mitigation adaptation, which was provided for by virtue of the Uganda National Climate Change Policy of 2015. So, albeit that, there is what we call now the National Climate Act, which is Okay, I guess the same challenge we keep having. My apologies again. These are challenges we have with the network that we have. But I was just emphasizing the fact that, albeit the fact that we have the PSA, we are now happy to acknowledge the fact that we have what we call the National Climate Act Change, which is 2021, and the National Climate Policy. And all these come out of the submission of Uganda's interim nationally determined contribution, what they call the NDC 21, which was ratified by virtue of the Paris Agreement in November. I have tried to switch network because I was using Wi-Fi. Let me try and use my data. Maybe it may be more stable. The Wi-Fi may be a problem. But forgive me again, my apologies, Mr. Moderator and the colleagues that we have here. So I was emphasizing the fact that by virtue of the fact that now we have what we call the National Climate Act of 2021, which most people may not be aware by now, and the National Climate Policy, all these come out of the submission of Uganda's interim nationally determined contribution, which they call the NDC 2021, which was appraised by virtue of the fact of the Paris Agreement of November 2016. And its essence was to tackle the greenhouse emissions. So unlike the initial NDC which we had, the interim NDC basically aims to further strengthen mitigation actions on one part, as well as adaptation in terms of actions. So adaptation basically remains the country's priority in response to climate change. And the absence of such a framework in this period, or the period prior to the imminent, challenges or the imminent explorations of sorts, have a lot of questions to answer on our part. And therefore, these are some of the questions that I cease to answer, or I choose to answer. Do we have a lacuna in effect in which we can particularly highlight, and in terms of resolving, notwithstanding the fact that we have an act as of today? Now, I capture that in the book that I will share with you hopefully next week. So the content basically is to examine the legal and the non-legal framework in as far as natural gas and the development is concerned in Uganda. We'll probably talk about a few definitional terms. I may not have the time because I think my slot is about an hour or so, but my emphasis here is to try to bring out some of those elements that I needed to be identified in as far as legal and non-legal, and also look at the shortcomings in terms of exploration, development of natural gas in Uganda, and how it has been carried out. Obviously, we are alive to the fact that Uganda is one of the youngest countries in terms of oil and gas production, and therefore has to do its part in ensuring that climate and environmental issues are protected in as far as gas exploration is concerned, and so that we don't have dire impacts or what other people would want to call resource curse of sorts. So whatever we do now, in as far as our law is concerned, it should be prudent. It should have done out what we call an exhaustive due diligence, so that we can be able to have and make even a comparative analysis with those countries that are already exploring natural gas. So what is natural gas? Natural gas basically is actually a mixture of gases with a composition that varies and depends essentially on the deposits from which it was obtained. It can also be referred to as dry when the components or other than things like methane that have actually been removed from the mixture. Or it can also be referred to as wet when there are other gases present in the mixture along with the methane. These are scientific terminologies. They may have issues with lawyers, but I'm sure you will definitely have to appreciate. So this distinction is important because it relates to the way the product is actually processed and even transported in the original choice of the deposit from wet to dry, as it were. So natural gas, for starters, was created perhaps millions of years ago through processes other than what they call fossil fuels or what they call coal or etc. So after its creation, it was either released into the atmosphere or trapped into pockets of what they call immeasurable rocks, creating what they call underground deposit discovered in the modern era. However, the combustion of natural gas is the cleanest compared to other fossil fuels, especially in far as carbon dioxide is concerned. But even these small emissions do not actually cease to contribute in terms of creating what they call the greenhouse effect. I think some of you are probably aware of the the mandate that has been, I don't want to call it the mandate, but the zealousness that has been expounded by Bill Gates in terms of trying to control greenhouse emissions because they realized the danger of too much emissions in the ground, the effects in the ozone layer, the effects of the greenhouse effects in terms of the glaciations, the ice lands, how much change it has in terms of the environment today. So this is something that whether or not we like, we must pay absolute concentration, absolute urgency, if you like, because of its colossal effects if we don't take that into concern. So natural gas, as I said, is an important determinant in terms of energy, not only to many countries, especially the producers, but also international organizations. And it's also prudent to note that, by the way, the advancements in terms of technology in the energy sector may be able to bring a revolution in the near future if we produce it in abundance, especially if it is clean in terms of uneconomic power. And therefore, it would help us to solve so many issues. That is important for us to note. So natural gas by far is cleaner than any other fossil, by the way. Call it oil or call it coal or whatever, with significantly lower emissions in terms of carbon dioxide or other pollutants. So that's why the emphasis should actually, in my opinion, be placed in terms of natural gas. When I was trying to share my book in terms of oil and gas, one person brought it to my attention and said, is it something that has been overtaken by events of sorts, in spite of the fact that Uganda is, quote unquote, just beginning in its terms of stages in terms of exploration? And then I argued and said, listen, we still have that argument. In fact, one of the chapters we argue in the book is in terms of renewable energy. We call it renewable energy, which is, again, some sort of future. In fact, countries like in the Middle East now, they're actually preparing for a post-oil era, whereas we're still preparing for a incoming era in terms of oil. These guys are now preparing in terms of post-oil era, which is something that is important for us to again appreciate. So that's the concentration that we choose to look at. We have to think outside the box, but also throw the box away. So we seek to examine whether or not the legislation that we have in place is substantive and is prudent enough in terms of creating a sustainable ground for us to explore this gas without any challenge. So those are the legal aspects that I want us to talk about briefly in terms of that. Now, for purposes of legislation, as I said, the keywords in terms of your definition, you will probably want, as I said, to understand what natural gas is. As I said, it's a fossil energy. I will not go into the nitty-gritties. You will find a more detailed book in respect to that. I will definitely give some free donations to the Law Society, so there's no doubt about that. In terms of natural gas development, also, there's also a definition, which is abbreviated as NGL. So you probably want to find out, or they may also contain what they call non-carbon, non-hydrocarbons, or even sulfur or helminths or nitrogen and such. We'll also appreciate that at a later time. And then we'll also try to talk about certain aspects in respect to its mixture, how natural gas is a mixture, how it's made, how it was created, in terms of that. But that's not important for now, because we may not be able to cover what we want to cover in terms of what is required of us now. For now, we just want to look at the law in terms of what is the law, in terms of where is it provided for, the legal framework in as far as is concerned in Uganda, and the constitutional mandate, obviously, the legislative, regulatory, or jurisprudential, or even managerial areas, together with the components in as far as the institutional, administrative, or even political or social, economic concerns, as it were. So those are some of the things that probably we want to to look at it. So in terms of non-legal, you want to talk about it in terms of the policy, obviously, professional or production gas production agreements, if you like, that are actually enforced, that would help you to give. I will move under some people. When you're doing scholarism, you probably want to justify what kind of theoretical framework you tend to appreciate. Or my theory in terms of theoretical framework is based on, among other things, to do with what they call the hoteling theory, or what they call the Hubbard production theory. The hoteling theory was developed in 1931 and presupposes or proposes that natural gas production volume should actually move in response to natural gas price and the effect of other factors such as natural gas price. For example, if you look at the OPEC production and the cost of gas production are well developed under this theory. So in bid to control such production. So when you're looking at the hoteling theory, it actually helps you to manipulate what they call optimal price of an accessible resource in relation to its scarcity or production, as it were. If you look at Hubbard, on the other hand, production model theory was first proposed by Marion King Hubbard way back, and it stipulates that the production is what they call, in terms of what they call a curve, bell-shaped, and is therefore symmetrical. In addition to understanding the production behavior, the production model is actually used with intent to forecast what they call a future production. I will not go into that because those are theories, legal theories that just help you to expound theories under which we academicians move. So I'm mindful of the fact that I'm not really talking to a predominant academic society, but practitioners of sorts, and therefore your interest probably is in terms of the law, as it were. So historical perspective, that one, there's no doubt that natural gas availability has actually, been there since 1920. Exploration was not undertaken until the early 1980s, and natural gas was not deemed to be sufficient in terms of quantities by our so-called colonial masters, and therefore warranting its mining. Post-colonial governments held the same perspective until recently studied the hydrocarbons in the Albertan region, especially in the northwest, where vast natural gas or significant volumes of hydrocarbons were actually detected in the so-called Albertan Graben in the 1920s. So that's also important for you to understand by way of history. In 2006, Ugandan government reported findings of what they call feasible volumes of natural gas in the Albertan Graben area, and they made about 21 natural gas discoveries. By the end of 2017 to 18, there was an estimated accumulation of natural gas reserves of about 672 billions. I will share the entire book. Don't worry.
I'm so sorry for the interruption.
Yes.
Do you think you can still share your presentation, or you can share it thereafter? You can.
I will share it after. Don't you worry. I'll share it after. Actually, what I'm going to do, I'll share the whole book. Okay. I have a whole book on this. So many of the areas you like them, case law and stuff like that. So, and this is about.
All right, thank you. Okay, proceed.
This is about 700 pages. So you can be sure that if you never wanted to share it here, I'll never have the time to go through it. But I'm just choosing only one particular chapter in respect of the entire. But don't worry, you will be home and dry in respect to it. Thank you, much obliged. So in terms of discussion analysis, as I'm saying, gas emissions, we have talked about them. We talked about the principle in terms of gases. We talked about the fact that we have carbon dioxide, of course, methane, and then the nitrous oxide. We emphasize the issue to do with the greenhouse emissions and the emphasis what it serves, the purpose. We were able to talk about the emissions in terms of the different gas emissions, where we talked about indirect gas emissions, which including carbon dioxide and methane. And then obviously we talked about their sources. And then we talked about how they are produced in terms of refining. And then we're also talking about the fact that certain countries have a challenge. For example, China, in terms of emissions, because it has colossal effects in terms of the consequences, if you like. If you're going to talk about types of gas emissions, then you probably want to talk about combustion gases, which consist of what they call carbon dioxide and minor amounts of carbon monoxide, which nitrous oxides or uncombusted compounds, things like methane and volatile organic compounds. If you talk about hydrocarbons, on the other hand, as a type of gas emission, then you want to look at it in terms of methane and primarily what they call alphate volatile organic compounds, which are released in the atmosphere. Now, as I said, for lawyers and for practitioners like you, your emphasis is in terms of the legal framework for gas emissions. For starters, one thing that you must take away is the National Climate Act, as I said. Remember, I talked about that, which tackles greenhouse emissions and was, came in force on 7th September 2021. And it was declared a day of International Day of Clean Air in terms of that. And of course, again, for purposes of advocates like you, the climate change policy for East Africa, which also urges partner states to develop what they call a consistent national policy, and as far as gas is concerned also. Obviously, you also want to look at the United Nations Framework Convention on Climate Change, which is also another, legal entity of sorts, which is also important. You also want to argue the Kyoto Protocol, and then obviously the National Environment Act as well. So those are some of the laws that are predominantly important on top of the ones that I told you about that are important in terms of giving you a basis under which you will understand and try to appreciate these components. So we will continue in terms of breaking down some of the more important things that are necessary for us in terms of the law. Obviously, the Constitution, you cannot undermine that. The Republic of Uganda Constitution, as provided for in Article 77(1), which establishes obviously Parliament in terms of vesting powers to make laws, and primarily this is also mandated by Article 244(2) of the Constitution in terms of governing the exploration of oil and gas, as it were. So again, that also becomes important in terms of the legality of it. And then if we're going to talk about other aspects, then we need also to look at other laws, the Land Act also, because it has also an impact in terms of how the environment will be affected. Access to Information Act is also another important one. National Environmental Act is also another important one. The Investment Code Act also is another important one. The Penal Code Act, obviously, the Income Tax Act. I know someone is arguing in terms of the Income Act, the Income Tax Act, the Wildlife Act, the National Forest and Tree Planting Act, the Public Health Act, the Water Act, the Public Procurement and Disposal of Assets Act, among other things. So all these are acts that are important for you as lawyers that you need to have on your fingertips. I have made a summary of these, so you don't have to worry. I will definitely send them to the moderator as soon as we're done, and all of them are captured in their details. And there's a lot of case law also for you who want to argue these matters in court. Okay, so you shouldn't worry about those particular components. I wanted to be as brief as possible because of the time that is given to me. This is a document, just only this document. This document has a lot of information in as far as the legislation for oil and gas is concerned. I'm not sure you'll find anything like this in Uganda. I can assure you that. And in terms of authors, I probably have about 1,000 authors who have talked about this. So in the interest of time, because like the document I have, is 187. There's no way I can do it in an hour. I'll be lying you. So, and the book itself, as said, is about 700 pages. So at this level, I would want to perhaps ask my able and competent moderator to further guide the discussion in case of anything that you may want to underscore.
Yes, Council. Thank you so much, Council Isaac Christopher Lubogo. That was a typical London lecture. The matter, especially regarding the laws. I'm sure colleagues will be having to look at your short slides of the presentation, which in my opinion was very thorough and actually some good time in our plenary discussions. So members are invited, please, because they are interested in your discussion. Maybe they can engage you on some of the legal issues that we talked about regarding gas emission in Uganda and the need to legislate because it is very, very important, aware of the climate change legal regime for the time we are in. Since the Paris Agreement of 2016, around that time, countries are pledging more and more money, I think 100 billion or something, towards clean energy. So it is very paramount and important, even for lawyers or for Ugandan government in our new nascent oil and gas sector to take care of the gas emissions. Since we have signed protocols as a country, for instance, remember we are also part and parcel of the Paris Agreement, which most countries are attentive to. So it is important that as we utilize our wonderful resources in the Albertine region, we also consider taking advantage of clean environment. And I think we have, by and large, a robust legal system, but of course we need to update it and amend it to sort the challenges of the capacity. So, ladies and gentlemen, you are invited to engage Council Vogo on a few things if you have. Please get into the chat room. If you want, you can unmute yourself with the permission of the admin, or you can even go to the Q&A and see if we can have a good discussion. We have 20 or so minutes or even more for this plenary. Thank you so much, ladies and gentlemen.
Perhaps I would also urge my colleagues, I'm readily available. My phone number can be shared by the moderator, and if you're interested in a more detailed paper, as I said, or even the soft copy, I will definitely give a donation to the Law Society of this book. It's about 700 to 800 pages and captures almost, if I just, for example, give you a little bit of insight into some of the things that you may want to look at in terms of this, you'll be, or maybe that may impress you in terms of what is important. I've actually talked about many things, beginning from concessions, beginning from PSAs, beginning from public trust doctrines, intergenerational provisions, aspects to do with environmental concerns, legality of soils are captured, and that's why the book. But feel free to engage me. I know you may not have the time to be as free as you want, but the moderator can share with you my number, and we can even engage. Pardon?
Yeah, Council colleagues are interested in your soft copy. Council Andrew Kabombo and Council Charlotte Katutu. They are all interested, and others. I think you'd be very kind of you to indeed share that information with the colleagues. Thank you so much, Council. Can you hear me, Council?
Yes, I can, loud and clear. I would definitely oblige. Your wish is my command.
Very humble, Council. Thank you so much, Council. Is there anything you'd want to add? Because we still have like 10 or so minutes. Well, if you, all members are also welcome to send in some few questions if you have. Same here, if I can have a soft copy, definitely. We shall make sure that the soft copy is readily available once Council shares it with their team at ULX or with us. We shall also be able to send you his business email and telephone contacts, we definitely have them. Thank you so much, Council. Any member with any submission, please? Ruth Birungi, yes, please. Go ahead. Yeah, I would be grateful for the book, Council. That's also a request from Council Birungi. All right. Thank you. Yes, Matthias Nalianya, please go ahead. Can you unmute yourself?
Yes, I have. Good morning, Mr. Moderator.
Thank you. Good morning.
Mr. Luogo, thank you very much for your paper, your presentation. We look forward to getting a copy of your book for further reading. But for now, I would request that you throw some light on the kind of legal milestones or legal things that a lawyer would look for if they are advising a client who would like to undertake a project, say for extraction of natural gas for commercial purposes. What's the legal regime? What are the kind of milestones that you would look for in trying to advise such a client? Either they would want to extract natural gas for sale for domestic consumption, or perhaps they want to use it to generate power. What things would one look at right from, I guess, licensing and so on? Thank you.
Thank you so much, Matthias, for that good question. I'm sure Council has noted it down.
I have tried to, unfortunately, during the time when the question was asked, my network kind of disappointed me, but I think the best thing to do, moderator, kindly note those questions for me, and I would definitely be honored to respond to them. And if you can send them on my WhatsApp, I can even send detailed discussions with these particular people. And I always encourage people to call, like I said, so that we have a one-on. It makes things better that way. We sometimes get let down by these internet things, as you know, which also reminds me of infringements on the right to the internet. I think some of you have probably looked at my book called Demystifying the Fountain of Honor, the constitutional mandate, where I argue in terms of those elements of whether or not I think the argument is that if you and I, who are supposed to argue the law, do not argue the law and protect the law and do things that we're supposed to do, then the argument is crude men and vile men will actually legislate their own laws in blood, you know, and that's the danger we don't want to go in. I think it was also Bernard Shaw who said most people see things that they are, and that's why, and I dream of things that are not, and that's why not. So this argument is timely, and I uphold the Law Society in terms of that. But also my emphasis, as I said, in terms of the future for oil and gas would be probably in terms of the renewable energy that, again, we also capture. Like I said, we have the regulatory, institutional, we have the environmental aspects, they're well captured. And also in terms of other things to do with the concessions, the PSAs are also there. We have even appended many of them and even made comparative analysis with Kenya and Tanzania in terms of the PSA. And then we also talked about dispute resolution, by the way. And even the idea that we probably need a unique court, you know, for handle our oil and gas, challenges, because our courts are overwhelmed, you know, in terms of backlog. So we need a unique court, perhaps, that can be able to capture that. We're going to capture all this. In terms of taxation regime relating to oil and gas, also we're going to capture that. Corporate governance, for example, corporate social responsibilities as well, aspects to do with extractive industries, transparency, for example, as well, and the enforcement. I know Uganda became a signatory recently, and therefore some of those things in terms of fighting corruption, so we don't undergo what we call the resource, the resource curse. There's a very big book, I think you've probably seen it, which is called The Resource Curse, which argues most of those things. Then aspects to do with decommissioning offshore and onshore gas installation, legislations and stuff like that. All those we have. and then inductive arguments also that are propounded by other people in terms of the future. We look in terms of the future. We were mindful of what's going to happen tomorrow. So, Mr. Moderator, I did not hear the other things, but I've asked with your permission so that those can be passed over to me, and I'll be more than willing to answer my esteemed brothers and sisters.
All right. Thank you so much, Council. I think that is very clear and loud. The former speaker was requesting to understand the best legal regime that can be followed if one was to follow extraction of natural gas. I think they were asking of the legal regime or the guiding law if one was to advise the client who would want to develop a natural gas extraction kind of in Uganda. That was, if I can paraphrase, that was the question that was asked by the previous speaker, Council.
Yes, and for starters, I told them starting point was the National Climate Act, remember? Then second was the National Change Policy for East Africa, which helps us to adhere to that. Then I also argued in terms of the Kyoto Protocol, then there were also National Environmental Act as it were. And then there was one that has to do with water something as well, which I argued in the beginning, if you remember, which called the Uganda National Climate Change Policy 2015, which talks about transformation, change, mitigation, and adaptation. So those are the basic things that someone has to have on their fingertips.
Oh, thank you so much, Council. Yeah, and members are still kind of requesting you, Council, to remember to share at least a simple presentation with the Uganda Law Society team. And also, yeah, I think that is a question, that is a state a comment from Sharon. Council Sharon, thank you. And then what are some of the possible legal landmines that Council should be mindful of when advising clients who want to invest in the oil and gas sector? That is Moses Paul Serwanga. Council, thank you for that question. What are some of the possible legal landmines that Council should be mindful of when advising clients who want to invest in the oil and gas sector? I think that is a whole host of legal documents or laws that we have. Definitely, we have to look at the local content laws in Uganda, the production sharing, and both from midstream, upstream, and downstream legislations. Definitely, any serious investor should be able to look at those legislations, because the model PSA Uganda operates under production sharing agreement. I'm sure some of you should have been privileged to have a copy of a model production sharing agreement, where these multinational companies are obliged or are contracted by the government of Uganda while they are doing their operations in the oil and gas sector. So those are some of the legislations I would mention. Maybe Council Lubogo would wish also to supplement or add a few other legislations that are very important for any investor interested in coming to Uganda. Council, are you there? Okay, thank you. Council also mentioned something to do with transparency and the EITI. Yeah, Uganda is a member of the Extractive Industries Transparency International or initiative, not international, it's the Extractive Industries Transparency Initiative. And we have a secretariat which is run by some important lady. And I'm sure it is very important when you look at environmental protection. The EITI is one of the kind of private sector initiative that involves government, involves the media, and involves also the NGOs or the civil society in ensuring that these the so-called oil and gas operations are done following the due processes. For instance, ensuring that there is protection of the project affected persons, but also the very important environment. And also, of course, our resources, make sure that those resources are used or are very well catered for in terms of transparency, but also ensuring that there is value for money, that once government receives these resources from different IOCs, then they are put to the use basically for the people of Uganda, not for a few people through corruption swindling and so on. So it is very important also look at that aspect of transparency and accountability, of which Uganda has already played to ensure that they are very transparent. Of course, some people would want to argue that, for instance, our PSAs are still confidential. Not many Ugandans, including you, the lawyers, or us, the practitioners in the oil and gas sector, can attest and appeal. For instance, which Uganda signed with Total or signed with the Chinese company and so on. So that is something we don't talk about. Then also council making something to do with the commission. The commission is also, this is after all operations, after the oil and gas operations. For instance, we have the East African oil pipeline. I'm sure you've all heard about the ECO project. The pipeline that's going to be running from Hoima to Tanga at the Indian Ocean. At a certain point, that will have to be dismantled. So the commission is also very, very important in terms of regulating or making sure that we take care of our environment in this day and age of clean energy or the clean energy. So that is one of the few aspects I want to talk about regarding what Council Isaac Christopher managed to elaborately present before you, dear colleagues. So if there are no questions, or if there are, please have the floor. We don't have many minutes. I think we have 10 or so minutes, but our plenary is supposed to be ending at 11 a.m. sharp. Yes, Council Samuel, please go ahead if you have any questions. You could please unmute and me. Council Samuel says that thank you for the presentation, Council Vogo, considering that the world is working towards clean energy. What plans does the oil and gas sector have in this shift? Is Council Vogo still on with us? But still, we shall make sure these messages are captured, and Council Vogo has promised you'll definitely be able to send them through later. Thank you for that question. But let me see if I can be able to react to your question again. Thank you for the presentation concerning the world clean energy. I already talked about our Paris Agreement in 2016, which has been renewed recently, and there are commitments that countries that wish to definitely develop their hydrocarbons must take care of in terms of what was agreed in Paris to reduce gas emissions by the year 2050 or so. So there are serious undertakings that governments must be able to follow. And I'm sure Uganda is definitely, if you are to look at our PSAs, definitely our production sharing agreements, it's not even the PSAs. If you are to look at our laws, the oil and gas legislations we have, they are very strict regarding environmental protection. But definitely as a poor country, we have no choice but to definitely develop our resources, because we need to take people out of abject poverty. So there is a very difficult balance there we have to do between utilizing our resources, but also protecting the environment. So thank you so much, ladies and gentlemen. If there are no questions, then we shall definitely be looking forward to the presentation that is starting at 11 from one of the best tax lawyers I know, Council Dennis Kakembo, who is going to take us through taxation of the oil and gas sector. Thank you so much. Dennis is very good he works with Bristol advocates and is very good at tax and the law. So let's look forward to that. Thank you, guys. Hello, ladies and gentlemen, once again. I hope we are all on. We are supposed to be having council take us through a taxation. That is supposed to be our next session. And so Dennis is supposed to be taking us through taxation of the oil and gas sector, of which I believe he has very extensive experience in tax, having worked for a tax firm, international consulting firm for some good years. And he's a managing director at Christo Advocates and a lawyer with a master's in oil and gas as well. So I'm sure he should be able to give us a very good insight into the taxation of the oil and gas sector, which has recently had, of course, we are very well aware of the recent tax issues we have had with our most of our partners in the oil and gas sector. We all remember the infamous handshake that emanated from a tax conflict on the capital gains tax that was supposed to be paid by these multinationals when they are selling their interests, or the so-called farm down of their interests in the Albertine sector, which ended up in London, and Uganda was the victor. So Council Dennis Kakembo, are you there? If you Council Dennis is supposed, of course, starting at 11, but if he was there, then he would definitely be happy to take on our discussion and utilize his wonderful knowledge or extensive knowledge and benefit from it. So in the meantime, as we wait for Council Dennis to come in, apologies because I went off, my phone blacked out. So I've changed and I'm now using a laptop. But hopefully we haven't lost each other since that time. The oil and gas sector is very interesting. It's regulated well by the host countries, but these multinationals tend to prefer utilizing international arbitral bodies. As you are well aware, the oil and gas sector is a highly capital-intensive sector, highly capitalized, with massive investments. So multinationals tend to favor handling their disputes, which we lawyers are very much interested in internationally. They tend not to trust our local courts. So that is some of the issues as members of the Uganda Law Society, I'm sure, should be thinking about of how best you can participate in solving some of those commercial disputes. These days, investment arbitration is the way to go, especially with these massive investments, the big investments. So we would want to think of how best we can participate in investment arbitration, not only in oil and gas, but also in mining, infrastructure, big power projects, roads infrastructure, and so on. So the oil and gas sector, whereas we know it is good to have investments, but it also tends to attract definitely big disputes that have a lot at stake. Yes. So if you have any concerns, any supplements, please feel free to raise your hand, or you can go in our chat room and make some submissions in there. Yes, in the event that Council Kakembo is unable to come, yes, Alan Selvika, please, Council. You have something to say? Any questions, ladies and gentlemen? You don't think of things about local content, I hope members here who would want to participate in the oil and gas sector have already registered on the Uganda, the NSD, the National Supplier Database, which is being hosted by the Petroleum Authority. You can do all that, members, through online, through your different platforms, either if you are or tablet or your phone or computer. Please endeavor to register your law firms or your consulting firms or your companies, if you have any companies that are already that are supposed to be supplying any goods and services. The previous presenters or panelists already mentioned regarding the opportunities under local content. There are some particular areas of services that have been ring-fenced for Ugandan companies, but remember the prerequisite before you can supply or take advantage of the local content law or regulations, you must be registered with Petroleum Authority under the National Supplier Database. Even for talent, those who want to register their talent or to register as practitioners, researchers, academicians, engineers, all of them, you would want to advise different companies to also register under the NSD, and also under the talent, the National Oil and Gas Talent Register, all of which are hosted by the Petroleum Authority, headed by our good friend Ernest Luwondo. So that's what I can say as of now, as we wait for our senior tax practitioner, Counsel Dennis Kakembo from Crystal Advocates. Thank you so much, ladies and gentlemen. Councillor, my good friend Elau, do you have anything you'd want to communicate? Any questions, any submissions or supplements? Are you there, Councillor Emmanuel?
Yes, good morning, Council Nicholas Mohereza.
Good morning, Council, please. The floor is yours.
Yes, thank you. I'm carefully following the proceedings.
Okay.
From behind the scenes and sort of learning a lot, especially from the oil and gas cluster or training of the day, because this is a very serious emerging area that many of us need to seriously consider going forward. So it's a very good opportunity for me, particularly also to learn from the experts in the field, and that's why I'm quietly here, listening in and learning very seriously. Thank you so much.
Thank you, Council. Thank you so much. Thank you for those insights, and I'm sure we shall all be able to benefit at the end of the day. This is part of capacity building. I'm sure as lawyers, we should be able to benefit really in terms of not only providing legal services, but also playing part and parcel of doing business in the oil and gas sector. And it is also very important that the most opportunities are actually being taken advantage of during this development stage. Remember, we are now having a Tilenga project, which is being developed by Total, joint venture partners, led by Total. So the biggest monies or investment is actually being injected in at this time in moment. So it is not good for us, really, members, to wait longer, to wait for first oil, or the first oil, which maybe would be in 2-3 years' time, according to the projections of the joint partners. which is definitely the government of Uganda, represented by the Uganda National Company, and then of course the IOCs, which is basically SUNUC and Total. So it is very important that we find a way of making sure we participate at this stage, not to wait until we have our first oil, because if you now go headed to Mombasa, you'll be able to understand that there is a lot of activities that is taking place specifically regarding the development of Tilenga. Tilenga is the master plan, or the area where oil is going to be extracted first. And then of course later we shall have Kingfisher, which will also be taken care of or managed by the Chinese under their company Sunu. So ladies and gentlemen, let us not wait for the first oil. Let us try to register with the national supplier database as companies, as law firms for purposes of Uganda Law Society, as businesses. If you have any interest in supplying, let's say, food, security, legal services, supplying materials like building materials, all of which have been ring-fenced for Ugandans. But remember, for you to take advantage of that, you must meet the standards, which are the threshold is quite high, being the oil and gas sector. And then definitely you also must be registered. You must have a trading license. You must have a TIN. You must have a certificate of incorporation. That is all. Those are some of the requirements that the Trade Authority will require from you to be able to be registered as a supplier, as a possible partner. Remember, one of the requirements under the national local content regulations, it is important for any business that cannot be supplied by Ugandans, there must be a joint venture partnership between a foreign company and a Ugandan. But for you to be able to do that, then you must be a company that is appearing on the NSD, which is regulated, I think, which is updated. That is a word. Updated, I think, every year. So you must be able to, for instance, file in your returns, members, for you to be able to benefit from this sector. Otherwise, we shall just keep watching as Ugandans, as of course other foreigners come in and take advantage of the resource which we just have here on our doorsteps. Thank you so much. Any questions, any concerns, please, as we wait for council, we just have only 3 minutes to 11. I hope Council Kakembo is ready to give us matter, I quote, and we benefit from his extensive tax and law practice. Thank you so much. Council Kakembo, you are very much welcome. I think we shall be waiting for Council Kakembo to come up. I think it is within his rights. The program was reading until 11, which is just a few minutes away. You can just take some water, sip some water, as we wait for Council Dennis Kakembo. Thank you so much, ladies and gentlemen.
Hello?
Councillor Dennis. Yes,
Are you able to hear me?
very loud and clear, Councillor Dennis. You are very much welcome.
Okay. Sorry, I joined a bit late. I've been told that the area facilitators finished a bit early on time, but I had been scheduled to start at 11, and that explains why I've only come in at 11.
You're on time.
Okay, yes. So what I'm going to do is I'll be projecting the slides. I'll be sharing the slides with you, which I'll be running through. And let me do that right away before I start the session. Okay, so I hope you're able to see the slides.
Very clearly, Councillor. Thank you so much. Please proceed.
Okay. Once again, a very good morning to everyone who is taking part in today's session. For this segment, I'll be taking you through the fiscal and taxation regime for oil and gas operations. And this is a very contentious area of oil and gas. In the perspective of Uganda, actually not only Uganda, but many nascent oil and gas producing countries, the fiscal and taxation regime has always tended to be a very contentious matter. And I will cite for you some examples within the constraints of the time that will justify and demonstrate my view. Just a brief background of myself. My name is Dennis Kakembo. I work at Crystal Advocates, where I am the managing partner. I am an oil and gas practitioner. I've done oil and gas since 2009, from the time when Heritage Oil was exiting and Tullow Oil was acquiring the entire stake. And I've had the opportunity of working in Uganda, Kenya, Tanzania, United Kingdom. And I've basically dealt with virtually all the oil and gas companies and their subcontractors regionally and internationally. So the purpose of this session is to create awareness of the fiscal and taxation regime in the oil and gas industry. You will note that the approach I'm going to take combines both fiscal, I mean, you could say it's a tax issue, but it's a non-tax issue. So I'll be blending both the traditional tax instruments that we know very well of, like income tax, VAT, customs, as a means of extracting value out of the oil sector. But even more to that, the larger part of the instruments that extract value out of oil and gas industry for the country do not fall within the category of the traditional tax instruments. It's the non-traditional tax instruments. And that's why I decided to add the fiscal and taxation regime, because a lot of the value is actually derived from the fiscal instruments, which are akin to taxation, that extract value, but not necessarily in the typical traditional tax instruments. But before I get into that, just very briefly, because how the issues I'm going to talk about will touch a bit of this, so I need to give it a bit of historical and background context. Now, the petroleum industry, or oil and gas, you could call it petroleum or oil and gas industry, is divided into three segments. Though some literature also divides it into two. So those three segments are the upstream, midstream, and downstream segments. Now, the upstream segment, also known as exploration and production, finds and produces hydrocarbons. Now, in terms of putting it in proper context, where we are, Uganda, the excitement that we presently have essentially falls under that category of the upstream. When you see Total, E&P, when you see CNOOC, and Uganda National Oil Company signing all these major agreements around kicking off Uganda's oil and gas project, they largely fall under A, which is finding and producing oil. Then part two, or the other segment, is the midstream, which essentially processes, stores, markets, and transports hydrocarbons or petroleum. Hydrocarbons, it's also oil and gas or petroleum. So the midstream provides a link between producing areas and the market areas. In the perspective of Uganda, in the classical illustration of oil and gas value chain, the pipeline essentially would fall under the midstream. Though for regulatory purposes here in Uganda, I think the pipeline is regulated. Sorry about that. So the pipeline would fall under the midstream segment. So the EACOP, essentially when someone talks about the East African Crude Oil Pipeline, just know that we're talking about the midstream. Then we do have the downstream, which essentially includes oil refineries, petrochemical plants, petroleum products, distributors, retail outlets, and natural gas distribution. So when you go down to the fuel stations to get gas into your car, that classically is downstream. Refineries, like the one we want to establish, would essentially fall under downstream. Though for regulatory purposes in Uganda, refinery activities are regulated under the midstream law. But by and large, in the classical illustration of it, it should be under the downstream segment. So I will not go into an overview of the state of Uganda's upstream oil and gas sector. A lot has been happening. You've been reading the press. You see tenders which are ongoing. You remember that monumental event that took place on 11th of April when Madame Suluhu was in the country together with Total Global CEO and Chairman Patrick Poyel, when they signed a couple of agreements related to Uganda's oil and gas project. So we have a lot of information, and I believe we know the applicable law and the players that are involved in. Then the midstream, that is the pipeline. Then, as I mentioned, the downstream, that is the downstream. That's where we essentially would have the refineries. Now, before I go and explain the actual fiscal and tax instruments, I want to give you a background of the theory that informs the fiscal and taxation regime in the oil and gas industry. Why do people usually say the oil and gas industry is unique? Why do the oil companies always demand that they should be given a special regime to apply to its activities? And why is it that fiscal and taxation matters are always very contentious in the oil and gas industry, even to some extent the mining industry? So what I'm going to explain is essentially the theory behind it. So basically, in the first thing is you have a contractual framework. The contractual framework essentially sets out the arrangement for carrying out extractive industry operations and approaches to allocating economic rent from the sector between the government and private companies. A lot of these agreements that are signed between the government and oil companies encompass a lot of provisions, a lot of things, environment, dispute resolution. It's a whole raft of several issues to consider. But of course, significant attention is focused on the fiscal issues, because the fiscal issues are the essence of the industry existing, because its fiscal issues relate to approaches of allocating the wealth from the sector between the government and the private companies. If the allocation of wealth between the government and oil companies is not perceived to be fair or competitive to both the parties, most likely the project cannot move on. And the reason why negotiations are usually protracted is that you have to strike a win-win. If it's a win-lose, then the project just cannot take off. So essentially, many of the challenges faced in the oil and gas industry may not be unique and actually arise in any business activity, just that for the oil and gas industry, they loom especially large. We are in businesses where we all pay VAT. We incur VAT on the rent that we pay. When you're buying computers or laptops for your office, you're going to pay VAT. And within the VAT system, there's a mechanism of you applying that input VAT to the output. And if the input is still a lot more, there's still a mechanism within the law for you to be able to get a refund from URA. Even in oil and gas, it can be like that. The only challenge is that because of the amount of capital spend incurred in the oil and gas industry, if you do not relieve certain tax levies like VAT, you're going to create a problem for the industry. And when I say that, how can I illustrate it better? Uganda's oil and gas project is estimated to cost about $15 billion. But for purposes of making it easy to compute, let's say it's going to cost $10 billion. If you do not exempt or you do not relieve VAT from the oil and gas companies at the point of establishing the infrastructure for oil and gas production, it would mean they would have to incur an extra 18% of 10 billion. So they would have to incur an extra 1.8 billion, which would be VAT. So the government would be collecting that from the oil companies, but it would also mean that the oil companies have to look for ways of getting that money. So one of the issues that always arose, or one of the issues where we tried to put government into proper perspective, is that a fiscal regime that taxes investments is not fair. Taxation should be aimed at taxing profits. So now, like for the oil and gas project, at construction phase, under the normal VAT regime, you will not be registered because you're not producing, you're not registered for VAT. Or even if you're registered for VAT, you're not producing. So there's no output against which you can apply the input. So you're always going to be in a refund position and you'll be incurring that VAT. So what that would mean is that if you had intended to borrow $10 billion for the project, you have to look for an extra $1.8 billion. So the project cost ends up becoming 11.8. As you might be aware, we are in a world today where capital is very tight, especially for oil and gas projects, as the environmentalists and strong lobbies are trying to compel the world to move to the renewable energy space. There's a lot of a push against the oil and gas industry. So capital raising becomes a bit of a challenge. So whenever you have a fiscal and taxation regime that further increases the cost of investment, or that further requires an investor to borrow more money, when the market is tight, it becomes a challenge. So that is why, as I've said, many of the challenges faced in the extractive sector are not unique, arise in any business activity, just that they loom large, very large. Then the other issue arises from the challenges in coming up with a contractual, legal and contractual design of the fiscal regime in view of the distinctive features of the oil and gas industry and the interplay between powerful stakeholders. You have two principal stakeholders in the oil and gas industry. You have the government, you also have the international oil companies. Uganda as a government is Uganda is a sovereign country. But look at our GDP. I mean, our annual GDP is about $30 billion. Look at the market valuation of Total, which probably is about $400 billion. So in terms of market valuation, Total is 10 times bigger than the economic activity generate in a year. When the CEO of Total is coming here, he flies in a jet similar to the jet that our president moves in. So he's equally powerful. He's the money guy, but the resources are owned by the government. So as the government is pushing the agenda that favors it exclusively, the oil companies would remind it that, wait a minute, Mr. Moneybags, If you don't dance to my tunes, I certainly will not proceed to develop the project. The government at that point in time would also remind the oil companies that this is a developed country. We are no longer colonized, so you have to be sensitive to the demands of the people. So it becomes very difficult if you don't have experienced negotiators who look at the bigger picture or even commercial considerations from both ends. Managing that ego to achieve a win-win can be very difficult. And that explains why negotiations in oil and gas projects tend to be protracted. So this also filters through how the tax and fiscal regime is established. Because as you will recall, I think Uganda's fiscal and taxation regime has been changed probably over 7 times. If you put into account the present changes which are being debated in the House, I think we've had about 7 changes within the legal regime from 2007. So it's that interplay and deliberations between the government and the oil companies that eventually lead to that. Then the other issue is, oh, wait a minute, sorry. I'm trying to move something here, okay. Then the sunk costs and long production periods. So what this means is that the oil and gas industry is very sensitive to anticipated tax regime in the design stage and locked in once investment is committed. The production profile of Uganda's oil and gas project is estimated to be around 25 to 30 years. Estimated, but it could go longer than that in view of improving technology. And why I say that, when you look at the north in the UK, production started around the late 1970s. It had been projected that by the dawn of 2000, production would have stopped, but many of the oil fields are still going on. So it's possible that even Uganda's oil production profile could go longer than the 30 years. But the oil and gas industry, unlike other industries, one industry where you have to spend all your money at once for you to be able to produce. The oil and gas industry is not like the pharmaceutical industry where you can ramp up. You're like, let me start with an investment of $10 million. When things play out well, I can increase the investment. But the oil and gas industry, you have to spend all at once. If you've not spent all at once, you can't get to a point of you being able to produce. And that explains why, when you look at the numbers of Uganda's oil and gas project, they're mind-boggling. $15 billion projected to be spent in a period not exceeding 5 years, when our GDP is $30 billion. So that means guys are going to spend half of your GDP on developing just a single project. So this is really significant. And once you've spent your money, it becomes a sunk cost. So the bargaining power shifts, because once you've spent $15 billion, even if government tells you that, you know what, I'm changing the tax regime, if you don't agree, move away. As an investor, your consideration at that point in time would be, well, let me agree to what they are saying. After all, let me recover the money that I sunk. So this is a fear that the oil companies always have at the back of their minds, in the sense that you're starting off a project when one person is the president, but that project is going to outlive regimes. President Museveni is likely to commission the oil and gas production in Uganda if it all goes on well in 2025. But even the next president, this project is going to find him. So at the point of negotiation, it can be a sensitive political issue. I remember it happened in Zambia when the late Michael Sata was becoming president. For him, he was campaigning on an agenda of renegotiating all the oil and gas agreements on the basis that the previous government had negotiated bad agreements, that it had ceded all their sovereign rights to China. Now, if this is a big fear, so that is why the oil companies are extremely key, that when they are negotiating those agreements, they lock in significant stabilizing agreements to the effect that even if the tax or legal regime changes, or even if there's any other regime that affects the sharing of the wealth, at least you renegotiate. So this explains why some of the discussions are protracted. And it also explains why sometimes you find unique legal provisions in the agreements. You're going to find stabilization clauses, which previously would bar you from changing any law that would apply to a project after it has commenced, oil projects. But nowadays, they allow a country to make changes in the law. But if a change in the law affects the sharing of wealth, then you go and renegotiate the fiscal or revenue sharing provisions in the agreement so that you restore the position as it was, as the project was starting off. Then the other issue is that the prospect of substantial rates, which can be extracted up to just less than 100% without causing any change of investor behavior. I remember when oil companies were locked into a dispute with the government over tax issues, a lot of the positions colleagues from government were raising were that, but Uganda doesn't tax oil regime that much. You go to Norway. Norway taxes the oil and gas industry up to about, I think, 90%. Now, that is really right, but it was misconceived. Now, there's something, what they call a supernormal profit. And I think this is what that statement means, the prospect of substantial rates. So a supernormal profit assumes that by the time I come and tax you, you've recovered all your investments and even the return on investment that investors are expecting from you. So anything that remains after is a supernormal profit, which even if a government chose to tax 99%, the oil companies will not have any issue. Of course, the challenge is that how are you going to determine that supernormal profits? You have to look into the cost of capital and borrowing money from that side. You have to look into issues of the risk profile. After all, they say the higher the risk, the higher the profit. So for purposes of investment appraisal computation, what risk profile are you going to attach to Uganda? Are you going to say because Uganda is near DRC, because Uganda is near Southern Sudan, it's a much more difficult place to do business and therefore risky, and therefore for purposes of calculating the interest rates or cost of capital, let us put it at 15%. This usually creates a lot of problems and challenges in the discussions. Then the other issue that brings about challenges in the fiscal and taxation regime is that resource revenues can be substantial and the primary benefit to the host countries. When you look at that table that I've shared, the data is fairly old, but it can drive the point that I want to convey. At some point in time, Iraq depended on oil and gas revenues and taxes and revenues therefrom up to the tune of 97%. What that would mean is that if oil prices collapse a bit, the government would under be so much fiscal pressure looking for revenues. And the way some governments operate is instead of adjusting their fiscal discipline so that they spend less in periods of low revenues, they want to keep it as it is. So if they want to keep the situation as it is, what the government usually do is that they ramp up taxes so that they collect more. So the oil companies are quite sensitive about that. And that explains why they put in a lot of buffers within the agreement so that during the course of the project, they are sure that you cannot have so many tax changes that make the project unpredictable. Then the other issue is the high level of uncertainty all through exploration, development, production, and closure. The oil and gas industry is extremely uncertain. You just never know what will happen. And this informs some of the provisions that are included. Then the other issue, let me just mention two. I can name out the rest. Asymmetric information, whereby policymakers are less informed about geological and commercial circumstances than investors, complicating rent extraction. So because the oil and gas companies have been at this game for over 100 years, they are far more experienced compared to nascent countries like Uganda or Somalia that are just discovering oil for the first time. So it takes a bit of time for the government counterparts to generate the expertise, both technical and commercial, to be able to appreciate all these issues very well. In fact, I've heard of a story of some delegation in some other country. It's not in Uganda, some other country. They were negotiating an oil and gas project agreement with the oil companies. The government team came up with a position that they wanted to present to the oil companies, and they agreed that that was the best position that they had with themselves to present. When they presented that position to the oil companies quickly embraced the proposals of the government. So the government officials at that point in time became concerned because they were like, why is it that the oil companies have quickly embraced our proposal? Could it be that there's something we didn't think through? I think something is not right. And they ended up withdrawing that. Now, that is a question of asymmetric information. If you're well assured, if you know what you're discussing makes sense, it's the best, you've done all the number crunching, you wouldn't have any doubts about a proposal you've made. So a lot of the negotiations between the oil companies and the international companies are marred with a lot of suspicion because of the inability for both these parties to be on the same page. There's always a suspicion that, you know what, based on how the international oil companies fixed the Middle East, how those initial agreements did not benefit those countries, perhaps they're also trying to negotiate the same. Of course, if you're dealing with a team that appreciates all the issues, certainly that can easily be discounted because it's a question of looking at a proposal that has been presented by the other parties and check it out, whether it makes sense or not from a technical point of view. Then lastly, the exhaustibility of natural resources, thus issues of sustainable development and intergenerational equity. Nowadays, unlike in the past, sustainable development is at the forefront of the oil and gas sector. In fact, one of the issues that makes the IOCs and their contractors, the CEOs, stay awake are not issues of raising financing, not issues of market, not issues of prices, but rather sustainable agenda. You have a very strong civil society that always picks up all issues that don't go right. If there's an oil spill, you can be sure the environmentalists are going to be on your case. If you're compensating the project affected persons and they are not happy because you've not compensated them well, be sure the international community is going to be on your case. And that can even lead to you failing to unlock financing because some of these banks, the equity principles require that you look into all those issues. So sustainable development agenda is at the forefront. And I think one of the issues which the ECO project has been encountering, there has been sustained opposition to that project. The civil society players are so strong. Anything that does not go right, they always pick it up and amplify it in international media. So this is a key issue, and it relates to the social license to operate in the oil and gas industry. Once the community has not embraced your project, you're going to have a lot of challenges. You're going to have the challenges the Shells have had in the Port Harcourt, the Niger Delta state, because the community have not embraced their project. I don't know why they didn't. Maybe some issues of the sustainable development agenda had not been very well addressed. I can also give you another example near home here in Kenya. Kenya had embarked on what they call the early oil production scheme. So they were producing oil at a low scale, not on commercial basis, but essentially to test the waters of what would happen if they were to embark on a commercial oil production, and then also send a positive vibe to the international community that, you know what, we are eager to move this forward. Now, this oil was coming from Turkana. Now, Turkana had challenges in insecurity. Now, whenever the rogues would attack and people would get affected, the people in Turkana would block these tankers that were moving, the tall oil tankers that were moving the oil through to Mombasa. And they would say that, you know what, we're not going to release these tanks unless if the government intervenes and make sure that there's security in this place. So sustainable development agenda goals are key. And that is why even within local content, in as much as you aspire that the nationals of a country partake in the oil and gas opportunities, you also need to have an affirmative action agenda that would promote and encourage the people around the project. They may not be as competitive as people from Kampala, but these are the project, people near the project. So you have to accelerate and bend the rules a bit to enable them to participate. If you do not, and they are saying myself, Kakembo, and other people from Kampala as the only beneficiaries of this project, it can raise significant challenges for you within the community, and that can lead the project to stop. So when these agreements are being negotiated, many issues are considered. It's in the interest of the government that exploration takes place quickly, not that you get a license and then you sit on it. Then environmental issues, training, local employment. But of course, the main one is a fair revenue share and the right to monetize, stability, enforceability. So these are some of the issues linked. Some of them could be linked to the fiscal and tax issues. Some of them may not be linked to fiscal and tax, but ultimately you'd expect that you'd find them in the oil and gas industry. Now, I will just briefly talk about the contractual framework for oil and gas industry because it has something about the fiscal regime. Now, there are two broad systems of granting petroleum rights to investors in the oil and gas industry. These are the concessions and the contractual arrangements that consist of the production sharing agreement, which we have in Uganda, and the risk service agreement. Previously, what used to happen was the fiscal regime was concession. The concession derives from the Anglo-Saxon tradition and culture. So when you go to the US, where commercial oil production first took off in Pennsylvania, I think in 1857, when Colonel Edwin Drake drilled and made commercial use of oil and gas. In US, the land is owned privately. Resources can be owned privately. So concession has a bit to do with that. And that is why when the oil companies moved out of the US and went into the Middle East, they pushed through the agenda of the concession. Of course, the concession was not well taken. Subsequently, when the Middle East countries discovered that oil and gas was very valuable, because of some of the terms which were considered to be unfavorable, like you would have a concession that covered the whole country. So you give a US company the right to explore the entire Saudi Arabia. You give, you ask for royalties, which are very minimal. And of course, it's understood why, because I mean, by the time the American companies went, or even UK companies went into the Arab world, these people, all that mattered to them was water. They didn't know that oil was that valuable. So people were riding camels and the like. So if someone gave you 100,000 as royalties, you would think you've made a significant take. So some of those initial fiscal terms, when eventually they came to discover that oil and gas industry was very valuable, they discovered that they got a bad deal. And that explains why developing countries are not very welcoming to the concessions. It's more of a historical bias, but the reality of the matter is that when you have good economists, whether it's a concession or production sharing agreement, apart from the sentiment and the political messaging around it, you can end up having the same economic results, because subsequently the terms of newer concessions were improved a bit, whereby royalties were increased, the taxes payable under royalties were increased. Then there was the increased participation of governments in controlling the activities of oil and gas industry, which largely the production sharing agreement covers. It's more sentimental because in the production sharing agreement, the idea behind it is that the resource is owned by the government, subject to the oil companies recovering the costs they've incurred and their profit share of oil. But by and large, the economics of it remains by and the same. Of course, the oil companies have a preference for concessions. And the reason why they have a preference for concessions largely derives from market valuation. Under a concession, all the oil that you produce, once it is produced, it is yours, subject to you paying royalties and taxes to the government. So in terms of booking the reserves, which inform the valuation, where the company is valuable, because you look at how much more oil does it still have to produce, how is it going to do it? A concession is more favorable, but that is just that, not very materially different from a production sharing agreement in terms of structuring and getting economic benefit that you would want to get. So now the risk service contract does not differ very materially from production sharing agreement. I think the only difference with it is that you have to be very prospective. With Uganda, it might be very difficult for you to do a risk service contract, but in Latin America, countries like Mexico, countries like Venezuela, or even Middle East, it's very easy to do a risk service contract. And what that means is that you get someone like Halliburton or an oil field company to come explore, and then you pay them back in kind when you make an oil discovery. I could explain a little more, but I'm seeing that I'm getting a bit constrained on time. So let me leave it at that. Now, on this slide, some of the fiscal issues that you would see in the oil and gas agreements, or even within the law, that are aimed at extracting value for the country include bonus payments. Now, bonus payments can take the form of a signature bonus or production bonuses. Now, a signature bonus is usually paid when you sign off an agreement. So let's say Uganda has, like we are now running a license round. I think one of the parameter of assessment, whether you're going to succeed to get a block or not, they would look at how much signature bonus are you offering on signing of the production sharing agreement. When you look at countries like Angola, there's a time Angola had a licensing round, and I think one company proposed to pay $4 billion at the bid auction as the signature bonus. So it can be a significant revenue windfall that the government can get. Now, production bonuses are usually payable when maybe production commences and certain milestones are achieved. The production sharing agreement could be worded in such a way that when production reaches maybe 100,000 barrels per day, you'll give us a bonus of this amount of money. So all these are aimed at extracting value, getting resource allocation to the government. Then the other famous one is royalties. Royalties are also known as severance or production taxes. And they can be specific or ad valorem. Specific in the sense that, ad valorem in the sense that you could say you're going to pay 10% of whatever is produced. Or it could be specific in the sense that, especially when you go in mining, that for each truck of sand taken, you're going to pay 20,000. That is a specific payment. Yet if you say that you're going to pay 10% of the value that comes out of it, that ends up becoming ad valorem. It takes several forms. It could be on a sliding scale, just like how you see how the pay as you earn computation works, or it could be a deduction of expenses system, or it could be a profit-based royalty system. I don't have time to explain all this, but the reason why there are these variations is that some scholars have suggested that royalties can kill a project. If royalties are too much, they can take away the incentive of oil companies or even mining companies to participate in production, because for them, they don't take into account the production costs. You're charging me at turnover level, regardless of whether I am profitable or not. So that was the criticism leveled against royalties. So all those things of sliding scale, deduction, and profit-based royalties are aimed at ensuring that at least you take into account some costs so that the royalties payable by the oil companies are a little palatable. Of course, royalties, it's a first tranche. It's a first tranche payment, which is aimed at enabling the government to recover something so that it can do something for the people. even before oil companies are strictly profitable, to pay significant revenues to the government. Of course, oil and gas production or discovery excites sentiments. I remember when we made the discovery of this oil in 2006, on 8th of October 2006, President Museveni and Mama Janet Museveni organized the Day of National Thanksgiving Prayers on 8th of October 2006. We were thanking God for finally remembering us. Unfortunately, I mean, it's 15 years down the road. We've not yet started to produce, but we're on the way to production. So it whips up public sentiments and expectations. So if oil production starts and the government is telling people, you know what, we don't have money because the oil companies are still recovering their money, that can be a recipe for disaster. So that is why you have these issues like royalties to whet the government's appetite during that period in time to be able to do some things for the government. So it's a means of achieving a win-win. And that is why I think a few years, 2 or 3 years ago, the government had come up with some rather punitive tax proposals. And the view some of us proposed was that the government was asking for too much in the sense that like income taxes are strictly based on profitability. Oil companies, because of the nature of the capital spend, they're going to take much longer to be profitable. So you're wanting to tax them as soon as oil production commences would be unfair. But government would have things like bonuses, royalties, or even a cost oil cap that they would utilize to be able to achieve a win-win, whereby they get some money, but then the oil companies also get some money so that you still encourage them to invest. But on the other hand, the government doesn't lose all to be able to provide for the people because the people will rise up. So, and then there's also cost oil. Now, cost oil, whatever the oil companies incur, they recover it. Not all, okay, majority of the costs. Some costs may not be recoverable, depending on the cost oil audit, which could be undertaken. But of course, most of the costs are recovered. Now, to ensure that the government doesn't is able to get something every year, there's what they call a cost recovery cap. Of course, if oil companies are going to spend $15 billion, annual gross revenues of oil production, when production starts, I think at peak production, you're probably going to have $3 billion. Now, if you allow the oil companies to recover all their costs at one go, it would mean that the government would have to take a sit back and then wait for the oil companies to recover. What are you going to explain to the people? So that is why in the cost recovery, there's a cap. The government, the oil companies could be allowed to recover 50% of the production per year, which would mean that there's maybe another 50 or 60%, which is available for government to take as part of its profit or its share of profits, and then oil companies. Then I'll not go into state participation. It's also a fiscal issue. Maybe briefly, state participation, you see UNOC is exercising government mandate, commercial rights. So UNOC is participating in these projects on behalf of the government. Now, state companies usually come in at a point when discoveries have been made. So it could be a carried interest or paid up, but I think in this case it was a carried interest. It's when the oil company spent all their money, then came and acquired the right without necessarily having to pay anything. So of course this can be a fiscal issue because the more the government takes as a participation right, it also reduces the participation rights and interests of the oil companies in the oil project. So it can be a fiscal issue. Then I briefly hinted about stabilization clauses. These are key. Stabilization clauses are hinges upon which the oil companies are able to ensure that whatever fiscal and taxation regime they have negotiated, even if there are changes within the law, nothing would happen. Now, they take very many forms. Previously, you had what they call a prohibition on unilateral change. This was very unpopular because it fettered a country's sovereign right and power. Because what it would say is that once an oil project starts, you cannot change your law to apply to that oil project. but this wouldn't work. So progressively, it's not the prohibit, it's the freezing clause. It would freeze the law. But progressively, they've changed. Now what we see, they are balancing clauses. You can change the law, but if the provisions in the law are changed in a way that the fiscal share or the share of revenue is affected, then both the government and the oil companies go back and negotiate. Then there's also what they call allocation of burden. Allocation of burden, which is quite interesting. When you go to Kenya, they call them state-paid PSCs. So what the oil companies take as their share is net of taxes. So if the government were to change changes within the law, it would mean that it is them that bear the burden of the tax, because we've agreed, I'll take net. It's just like when someone negotiates a net pay contract. Whatever you pay as gross is up to you, but my net remains guaranteed. So it's the same with that kind of stabilization clause. It's also a form of stabilization clause. Then another issue where tax and fiscal issues are quite contentious is assignment of rights or farm outs. Of course, the way the oil and gas industry works is that before you make a discovery of oil, your risk profile is high. So you cannot attract the big boys. The Shells, the Totals would be reluctant to come and in Uganda before any discovery has been made. And that is why, even in the perspective of Ugandans, the resumption of exploration activities were heralded or marshaled by smaller players like Heritage Oil, which was headed by Tony Buckingham, a man who had appetite for risk. Then you had Hardiman Resources, which were fairly smaller companies, and then Energy Africa, and then Tullow Oil came in. So it's after we made a discovery that bigger players like Total and CNOOC actually came in, and they are now moving the project to developing the oil and gas resources. Now, those transactions are usually misunderstood. When you say oil licensing changing hands, the view that people usually have, or people that had back then in 2009, was that, windfall profits are being made. Uganda's oil is already being traded. People are making money. It could be, but it's not usually the case. You're moving out the smaller players so that the bigger players can come in. And if your fiscal and taxation and legal regime discourages bigger boys to come and participate in the oil and gas industry, you're actually shooting yourself in the foot. So many of the challenges we've had in Uganda's oil and gas industry have arisen from this misunderstanding of what is an assignment meant to do. The delay we've had, of course, delays have been several, but largely related to tax, have always arisen on the transfer of licenses. Should capital gains tax allow? Should you allow you to take the cost oil that the other guy incurred? So the disputes were massive, and if you recall, in 2019, it was a mother of all fights and battles as a result of that Tullow farm out transaction. Of course, that Tullow farm out transaction, or moving out of Uganda, was a bit different. Because when you look at when Heritage Oil was leaving Uganda, Heritage Oil, for them, their model was that find oil, sell, and then cash out, take your money. So in that instance, you might be justified to tax. But for the case of Tullow Oil was constrained on financing. So they made a decision that, you know what, let's cede part of our interest in exchange for consideration, which would be that you do not pay us the money. It was just an insignificant portion of money which was going to be paid. But when we go to development activities, setting up the pipeline and production profiles, rather than us paying the money, let Total and CNOOC incur that on our behalf. So, of course, when you look at the tax law as it is, that is consideration. That is revenue, which is taxable within the eyes of the law. But, I mean, that is the law. But when you look at the policy consideration, it's a bit strange that you're focused on taxing money that is earmarked for investment. Because if Tullow Oil had needed to spend $1 billion and you take away 30% of that, they would still have to go elsewhere and get the other 300 million. And you as a government, you're taking that money at that stage, yet you're frustrating the project to move ahead. So that is what I can say about the farm outs. Very contentious, not only in Uganda. Remember, we had big issues in Tanzania. Even in Kenya, we had big issues. Even in Mozambique, when Cove Energy made a big discovery of oil to attract Total and PTTEP to come in, it was a big issue. It's not that it was resolved much earlier in Mozambique compared to the time that it took in Uganda. Then there are annual payments, which oil companies pay based on the acreage they hold to the government. It's also a means of getting out money. The rest on that slide may not matter. Now, was I supposed to do 50 minutes or supposed to do an hour? But I request that you give me, in less than 20 minutes, I should have been able to finish. I would like to go through this and buffer where I may not have explained well. Now, the fiscal terms or fiscal and taxation terms under the oil and gas regimes. Now, royalties. Does Uganda have royalties in its fiscal regime? Yes. When you look at the model production sharing agreements, you see that oil companies have to pay royalties. Even Tanzania has the same. Even South Sudan has the same. Now, when you go to Kenya, under the old regime, the old PSAs do not incorporate royalties. But that does not mean that Kenya is in a worse position because it doesn't have royalties. There are so many ways of skinning a cow. I remember there was a big headline in the Standard around, I think, 2016 or 2017. The Standard is a big newspaper in Kenya. So the Standard was saying that Kenya negotiated a bad deal because compared to Uganda, Tanzania, and South Sudan, there are no royalties, so this is the amount of money we're going to lose. That was not correct. I may not have royalties, but I patch it up on the cost recovery. So cost recovery is how much per year can oil companies recover as part of their costs based on the production, the oil produced. So you might find that if Uganda has a royalty of 5%, they're going to take into account that in the cost recovery. So rather than have a cost recovery cap of 55, they might make it 50. Now, when you go to Kenya, because they don't have a royalty, rather than have a cost recovery cap of 50, they can make it 55%. So you recover less by 5%. So economically, you'd be able to achieve. That is why in the beginning I said sometimes the question of nomenclature. When you have good economists who can sit down and do the number crunching, all that can be achieved. So cost recovery is the norm in the production sharing agreements. And because Uganda, Tanzania, Kenya, and South Sudan have that PSA, you'll find that cost recovery is there. Then stabilization clauses. Yes, Uganda has stabilization clauses. Tanzania has, Kenya has, South Sudan has. It's very difficult for you to be able to attract investment in the developing world from the Western world without the inclusion of stabilization clauses. All major infrastructure agreements are protected. Umeme, the Bujagali, all major infrastructure projects, you'll always find stabilization clauses, which are aimed at protecting the investment from sudden changes within the law. Could be fiscal. Well, they may not even be fiscal, but actually affect the operation of the project. Then local content, it's not an entirely fiscal. Well, it could be, actually, it's a fiscal issue because if the local content regime is very stringent and unrealistic, it can increase the cost of doing business. And if you're increasing the cost of doing business, that means that the oil companies and the government would have little to take away because it eats into their profits. Then state participation, all governments can participate in oil projects. Even in Uganda, you see you have Uganda National Oil Company and its several subsidiaries taking part in the production, facilities, and even the midstream, the pipeline. Of course, I recall when the senior executives of UNOC were before Parliament early this year, when they were trying to ask Parliament to borrow money. Parliamentarians were not happy that Uganda had only taken up 15% stake in the pipeline. They were saying, oh, Uganda has not got a good deal. How could this be the case? So we ended up, it was a back and forth, and I think the MPs almost threw it out because they said Uganda wasn't getting a good deal. Of course, the East African crude oil pipeline is not very profitable. That project is only existing solely for the project of monetizing the resource. Because we don't have a refinery, or if we have a refinery, it's going to come a little bit ahead. Uganda's oil would be stranded unless if you have a pipeline that conveys the oil out of Uganda and takes it to Tanga so that it can be taken to the markets where it is sold. So look at the pipeline as another cost center that it's into. It's a cost, an inevitable cost that you have to incur for you to be able to produce Uganda's oil. So it is not very it's profitable, and in any case, significant profits are not at the profit. Are not and the profits which are going to arise from the ECOP bill. The profits are at production. So the lesser Uganda reduces the cost of building the pipeline by giving away so much incentives, the more economic value that you protect at the upstream, so that the government is able to take a lot more more profits. So basically, I think the financing structure of the East African crude oil pipeline is aimed at ensuring that at least the project funders, the equity and the loans and the return on investment, that the tariff revenue it will earn is able to pay for that. And then just a small, I think, profit to the project sponsors that include UNOC, TPDC, CNOC, and TPDC. But the ECOP itself is not looked at as being as a vehicle of making so much profits. It's inevitable that you need to have it for you to be able to produce the oil. Then I spoke about the annual fees, which are paid based on the acreage that you're holding. Then I spoke about the bonus payments, which could be signature when you're signing the agreement or when production ramps up. Then there's also what we call the additional profits tax. Uganda has a semblance of that, even Tanzania. Actually, Tanzania, it's embedded within the PSA. It's a strict one. It's a pure one, though it's because for it looks at cash flows which have been generated, then the cost of capital, then you discounted factor, which is quite interesting because the discounted factor, how you arrive at the discount factor can be contested. So what Kenya has is that when oil prices exceed $50 per barrel, then the oil companies would be expected to ramp up. The government takes more share. And also when you look at the income tax amended bill number 2 of 2021, which is presently before Parliament, there's a proposal which has been put there in the law. And that proposal is on basis that when oil prices exceed $75 per barrel, the government can slap a supernatural profit. I've forgotten the rate which is included there. But I mean, this is a win-win. It's aimed at ensuring that when, prices are cyclic in nature in the oil and gas industries, that when prices are high, the oil companies and the government are able to share in those supernormal profits. Of course, in the perspective of Uganda, how did we arrive at that? After the 2019 disagreement that threatened to derail Uganda's oil and gas sector completely, the oil companies and the government went back on the negotiation table. Now, the truth of the matter is that Uganda, because of our oil discovered not being very significant, Uganda's oil project was not meeting the investment hurdles. So the oil companies were clear to the government that, you know what, our shareholders are going to sanction this unless if the return on investment is 15%. I think at that point in time, it was probably around 10 or 11%. So a lot of things had to be done within the fiscal regime, including modifying the cost oil cap, ABCD, to ensure that the project became profitable, to be able to reach the investment hurdles for final investment decision to happen. So all that happened, and it could be that this additional profit was a concession. You've given me so much, but let me also give this. So that is a concession that happened. Then ring fencing. What ring fencing means is that each block, now there are 3 blocks which are going to produce. So for tax purposes, or even purposes of determining royalties, you do not combine all the revenues from this block in one pot, despite the fact that the owners are the same. You ring fence, you look at it individually. And what that means is that if block A is profitable, you're going to pay taxes on that. If block B is not profitable, you not pay taxes. If block C is profitable, you pay on the basis of those individual blocks. But if you are allowed to do a consolidation, you might find that when you consolidate the other block, which is not profitable, it wipes away all the profits and the government could lose. So ring fencing is very common in the oil and gas sector. Even in Uganda, you do have it, even Tanzania, Kenya. Then other factor, it's ratio of production vis-a-vis expenditure. One of the criticisms which have been leveled at the production sharing contracts is that the way profit oil is shared is not linked to profitability. So the idea is that when you look at cash flows which have been generated vis-a-vis your expenditure, the ratio you will get is able to demonstrate whether you've been able to recover all the costs you've incurred or not. So the ratio will initially start off when it is less than 1. But once the ratio goes above 1, it would mean that the oil companies have recovered all their costs, not necessarily the discounted costs, but maybe the cost of incurred. So at that point in time, the share of the profit oil increases. The government starts to take more because the oil companies have significantly recovered more. And when the ratio is still below 1, the oil companies will take more because at that point in time, they are in the mode of recovery, their investment. Then the second last slide. Do we have capital gains on farmhouse? Yes, it's the position across Uganda, Tanzania, Kenya. Do we have the capital gains rollover relief? Uganda has it, Tanzania has it, Kenya does not have it. Now, capital gains rollover relief, essentially the idea behind it is that if you're doing a reorganization or if you're transferring assets between related companies purely for the purposes of restructuring to make the project better organized, you do not have to pay tax, even though when you say a transfer has happened, in the strict sense of it, there has been a disposal. But because it's moving from the same owners, nothing has been cashed in. So capital gains rollover relief is supposed to achieve that. When you look at the East African Crude Oil Pipeline Bill, which is before Parliament, the provisions around transfer of interests are very, very, very comprehensive, better than even what you find in the upstream. Of course, the reason why they are that comprehensive is informed by the history we've had. There have been a lot of challenges and conflicts and disputes around that. So this time around, the oil companies made sure that the provisions are very clear so that transactions which are aimed at unlocking financing do not crystallize capital gains, because it would be a bit strange, because you might find that a company, maybe Tullow Oil or maybe CNOOC, is holding the 3 licenses in one company. Now, with financial, the condition they might give to be able to finance that project, they might require that you move one of the licenses into a special purpose vehicle. Now, when you move that license, because it has been transferred from entity A to B, typically that is a disposal. And that disposal under the law, if you look at the law in the classic terms, that is a disposal. So what is the cost base? What is the consideration? So you pay CGT. But look at the idea behind it. Move this asset into a special purpose vehicle for financing to be unlocked. So if you tax such transactions, it ends up becoming very difficult. Then indirect disposal of license interests. This has also tended to be a contentious issue, because the oil companies, and even I can give you an example here. Of, you remember when Bharti Airtel was acquiring Zain, the acquisition did not take place locally. Zain Africa was incorporated in Netherlands. And Zain Africa BV Netherlands held shares in all the African jurisdictions. Yes, please.
Just sorry for the interruption, Council. We are still waiting for the next session. So please take your time. You have like 10, 15 minutes. So please take your time and explain with a good presentation you have for us. Thank you.
Okay. Okay. Yeah. So indirect disposal of license interests. For you to appreciate it well, let me drop back on what I had started. The Zain Africa. So when Bharti Airtel was acquiring all the telecom interests in Africa, they did not come to Uganda. They just went to Netherlands. And that issue which arose was that, you know what, this asset, the disposal did not take place in Uganda. So if the disposal did not take place in Uganda, why should the Uganda Revenue Authority tax it? So that is why when you look at section 79, which deals with source rules, it has been tinkered with many times, changing the provisions to make sure that such provisions which happen outside of the country can be taxed. So in the oil and gas industry, that is very common, very common. I think even that was the issue here when Heritage Oil was moving out. I think they had initially been established, was it in New Jersey or Guernsey? And then they moved their domestic jurisdiction, their holding portfolio to Mauritius. And there was the expectation that maybe the Mauritius DTA with Uganda could help them so that the sale of the rights here could not be subject to tax. And I think also the other issue in contention before the Tax Appeals Tribunal in relation to the some cases here relate to where you acquire rights to a Ugandan company through a holding company which is outside of Uganda. Should that be taxable or not? But under our oil and gas regime, at least that loophole was sealed. Even Kenya, I think about 4 years ago, when I still worked there, there was a change which was aimed at making sure that you capture the indirect disposal. But of course, that being the case for oil and gas, the law is, but in practice, it's not been tested. And the calculations, the computations, the valuation can be a bit challenging. And I think that is what Tanzania has, because Tanzania, it's a very contentious matter. That law was introduced in 2015. Supposing I hold, as the holding company in Netherlands, I hold 8 licenses in Africa. So you come and pay me to acquire me in Netherlands. So what should Uganda take? What should Kenya take? What should Tanzania take? How are you going to value the value that Uganda contributes to that whole sum value, which is attributed to the holding company in Netherlands? So it can be interesting. Then withholding tax, yeah, we have withholding tax obligations. I think for the upstream activities, when you're paying to a non-resident contractor, the rate is it lower? It should be 10%. And then I think for ECOP, for the service providers, you pay 5%. And then dividends, and I think interest in the East African crude oil pipeline project, there is nothing like withholding tax. Of course, don't say that it is a bad law because Uganda is not collecting any withholding tax. As I earlier mentioned, the pipeline, it's a necessary evil. You need it to produce Uganda's oil. So it becomes a cost center. So the more you make it costly by loading all the tax incentives, the tax cost there, it will end up coming through as a cost, and it is going to affect your wealth at the upstream project. And of course, the way these international players or service players operate, the guy will tell you, me, I'm coming to Uganda to drill oil. I want a net pay of $1 million per day. If there's withholding tax to be paid, it's up to you. You're going to bear it. So as an oil company, you end up bearing it as a cost by grossing up. So it becomes difficult and challenging, and it can be a cost. Then transfer pricing, of course, it's a significant issue, and even in the oil and gas industry, it's common, because you're going to find that in doing a lot of the work here locally, Total has a team of expatriates who are based in experts in the sector, who are based in France, who will be supporting the activities here. So transfer pricing sometimes has been abused, whereby you erode value by transferring value from a country where tax rates are much higher to a country where tax rates are lower, so that you strip the taxable base. So there's a lot of scrutiny, even from a cost recovery point of view. Those costs are closely scrutinized, but even from an income tax point of view. And then double tax agreements, they do apply, especially when it comes to withholding taxes. And there's a recent case which was handled by Council Vironji, I think about 2 or 1 year ago, the Target Well case. Target Well is a UK-based company which was drilling oil. Now, in the course of drilling oil, I think they had a rig in Uganda. So the URA, they hired a rig from their parent company in the UK and brought it here for a few months. So the URA had wanted to tax the payments which are being made on that movable asset on the basis that this was a royalty. Of course, the gist of it was that when you look at the DTA between Uganda and UK, I think for movable assets, the right of taxation is only given to the country where the person is resident. And in that particular instance, the right of taxation had to be on the UK. But if there wasn't that DTA, Uganda would have a right to tax. Of course, Justice Wangutusi arrived at the right judgment, though how we got there, he did not consider, I think for him, it took more the permanent establishment route. But from my end, I thought the most correct position was, the answer would have been the same, but the DTA provision in relation to that. Then VAT, as I mentioned, oil at a construction stage, oil companies are not producing anything. So they can, of course, under our law, they can register for VAT. Now, if you register for VAT, whatever cost you incur in terms of input VAT, you can claim it back and get a refund from URA. But you know how refunds operate. It's very difficult to get a tax refund from tax authorities. In any case, usually when you apply for a refund from URA, they will do an audit on you, which will most times put you in a payable position. So oil companies do not like that kind of stuff. So what Uganda did, which is also similar to Tanzania and Kenya, was that we call it deemed paid. Whatever service you're buying from someone, they will charge VAT, but you not pay VAT to the service provider. And similarly, the service provider will not be expected to account for that VAT to the oil companies. It makes a lot of sense. It's a neutral position in the sense that you manage the costs of the project. Then the customs, when you look at the 5th schedule of the East Africa Customs Management Act, I think paragraph 30-31, all inputs and items for oil and gas exploration development should not be subject to import duty. It's the same when you look at the East Africa crude oil pipeline bill. All those items are exempted from taxes. But of course, the East African crude oil pipeline bill is more interesting. It clarifies a lot of issues that still remain a gray area. It's what we call infrastructure development levy or associated fees. Like when you're bringing in a car here or any other item, there should be that infrastructure levy of 1.25, which essentially is aimed at building, I think, your infrastructure. Now, I think under the upstream regime, when you look clearly at the law, if you look at the law and ignore the spirit of the PSAs, you could argue that that levy applies. But the East African Corridor Pipeline Bill has been very clear that even those levies or equivalent should not apply. Of course, the idea behind this is not to deny government revenues. It's just managing the costs of the project so that you have as little as to borrow for the capital investments. But even if, those costs were to be incurred and the oil companies were able to recover all that, it would mean that they would recover the same as the cost oil. And if they recover it as a cost oil, when you're doing a project evaluation, there's what we call a project payback. If I have to recover more over a longer period of time and the payback is longer, then the project becomes unattractive. Yet if you just remove it altogether, no one pays it, no one takes it. You're in a much better position because I don't have to borrow more. The project payback, instead of being 7 years, it ends up being 5 years. It becomes profitable. There's also net present value in these indicators, which, of course, the longer it takes for you to recoup the investment, the more the rate of investment that would be required. So all this can affect investment decisions. And of course, projects are sanctioned by board members who are very busy. He's probably never been to Uganda. He's never been to Uganda. He's a guy who plays golf. All he will ask from his investment advisor is that run for me the NPV. What is the NPV of Uganda project? Run for me the payback period of Angola, Uganda, Nigeria. So on the basis of only that, because of you not tinkering around with your law very well, you find out that your project fails to hit the investment hurdle. Then maybe local government taxes, then stamp duty can also be an issue. Then bilateral investment treaties can also affect. Now, bilateral investment treaties in our practice, we do not encounter them that much, but they can also be instructive because a bilateral investment treaty enables an investor to directly take on a state in an international tribunal. Ordinarily, a company is not a state actor. So if you go to the international courts, you'd expect Uganda versus Kenya. But with bilateral investment treaties, if I have an investment in a country that has a BIT with Uganda and any of my rights have been violated, I can actually premise on that. And I recollect some of the arbitration which didn't take off, but which were almost taking off by Total and Tullow Oil were premised on the bilateral investment treaty between Uganda and UK. So I think bilateral investment treaties, why the investors like them is that you use it as a dangle. If you have, a country that would like to be held in high regard, you remind it that, you know what, my rights have been violated. And if my rights are violated, I can exercise my bilateral investment treaty rights here to take you to arbitration. And at that point in time, maybe the government can review or go on the negotiation table a bit with you. And of course, one of the examples that is usually cited, when the late President Hugo Chavez was still president of Venezuela, there was a wave of resource nationalism that happened. Oil prices ticked up and the agreements were not flexible enough to cope with that. So this guy nationalized all the oil companies that were operating in Venezuela. And one of the companies which were affected were ExxonMobil. Now, ExxonMobil, the holding company, had been set up in Netherlands. And the Netherlands had a BIT, bilateral investment treaty with Venezuela. So they went under that, and they were saying the manner of expropriation was not fair. So I think they got the award in their favor, though I think the award, I don't know whether they settled on the quantum of the award, but they were not very happy on the quantum of the award. So by and large, that is my presentation on the tax and fiscal issues. As you all note, I've illustrated a bit on the traditional tax instruments, but I've also shed significant light on the non-traditional instruments, which I've branded as fiscal, which largely derive from how the oil and gas industry has been structured from way back. But by and large, these fiscal instruments in there serve the same purpose that taxation does. The traditional tax instruments do, which is extracting value from resource production to the government. So I think that marks the end of my presentation. I'll go back to my colleague, Nicholas, and I think he can moderate the plenary session and the questions.
Oh, wow. That is wonderful. If we're in a hall, we should be clapping for you, Council. My senior learned friend, Council Dennis. Thank you so much.
Thank you.
That is really good. We're tapping into your deep expertise in this sector that you command very, very well. We are very humbled, Council. Thank you so much.
Okay, thank you so much.
Council Solomon had earlier on asked you to comment further on the effect of the ECOP project. I don't know to which angle, but that was his question in the Q&A. Thank you, Councillor Dennis, for the presentation. Briefly say something about the impact of the East African crude oil pipeline.
Okay, I think I had briefly spoken about it, but what I'm going to explain now is more from a geopolitical view of things. If you recall, before Tanzania pulled off a major coup d'etat and the pipeline route went to Tanzania, it was more or less assured that Kenya was having the same. So Toyota Shusho did a study. I mean, it was more or less like a foregone conclusion that the pipeline was going to go through Kenya. But the late President Magufuli, together with Total, were able to pull off that coup d'etat that the pipeline went through South Tanzania. Of course, in terms of benefit, fiscal benefit, Tanzania gave away too much. Tanzania is not charging even a transit fee. Usually when a pipeline is going through another country, there's a transit fee which is charged. And that transit fee is meant to compensate for the disturbances and the land that they've given you. So Tanzania gave away too much that if you are a purist, an economic purist, you could say, no, this wasn't a good deal. But I think what the late President Magufuli was actually looking at was, which also helps Uganda in a way, you're opening up northern Tanzania. Whenever the pipeline is going to go through, you're creating infrastructure. And the pipeline is going to terminate at the port of Tanga. So the port has got to be dredged up. By dredging it up, it's going to be like Mombasa. So you're opening it up, you're creating infrastructure, you're opening up the port, and over time, you're going to have a lot more traffic of goods that will go through there. And that is the benefit that Tanzania would actually get from that project. But even more to that, for Uganda, it's not a good idea to hedge all your eggs in one basket. If you recall, the post-election violence of 2007, it showed us how susceptible we were to what was happening in Kenya. When the Rift Valley violence was going on, Uganda became a no-go zone area because you couldn't take your goods through there, and we suffered. So now by having an alternative route in Tanga, it makes it better for us. Now you have almost comparative routes in terms of distance that you can rely upon. And then it also becomes competitive. So Kenya and Tanzania will have to give us the best offer. If you don't give me the best offer, I would not be able to come and use your port. So as a country, we benefit beyond the oil and gas production, which is going to kickstart off that. So I think that is the fairest view I can give. I don't want to go to go into the legalese and the much more technical issues. I think the geopolitical picture of it is better, unless if there's anything specific in relation to that that should be explained.
Thank you, Council.
Okay.
Any other questions? And maybe, Council, you'd want, I know you are very much privy to some information which some of us might not have. I know your priest advocates has been consulting for some of these oil majors. But
the information could be confidential.
I know. But also being the fact that this is a discussion which is engaged, which is with some of our colleagues, senior lawyers and colleagues from the profession. I'm sure they would want to understand that this would be shared maybe from an academic point of view, and it's not supposed to be. But I would want basically to look at, well, did Uganda get a good deal? Maybe that is something, a question which is normally popping up, especially with the ECO project. Did we really get a good deal? And then another issue with the humbly request is also on the timelines. How far are we going maybe with the activities going down there at Tirenga and so on? How far, what is the timeline for our first oil? And then maybe the other issue I would kind of ask you to emphasize from a business point of view, lawyers late participate in the oil and gas sector. What is that? What is up for grabs? Thank you.
Thank you so much for those three wonderful questions. Now, did Uganda get a good deal? That's a difficult one to answer, but let me see some of the indications that I can really give. A bit from the late 1920s, I'd like to give a bit of a historical perspective to this, where crude oil was seeping through the rocks in Western Uganda. And at that point in time, everyone thought that maybe there's oil here, but it didn't make sense to come and explore the oil because the oil was so far. By that time, they were easy to reach wells. Oil was you just go onto the sea, you bring your tanker, and you're able to take the oil. But here you are, Uganda, you have a resource that is stranded in that particular place, very far with no infrastructure where it is. So inevitably, it would mean that the cost of producing it would be a lot higher, and it would not attract people to come and explore it unless if the country or the world had run out of oil. So progressively, the easy oil was exploited, and the oil companies started to look far and wide to be able to get whatever oil they could get that they could find. Now, for the case of Uganda, when President Museveni came into power, there were several renewed efforts which were focused on realizing Uganda's oil and gas potential by embarking onto proper exploration activities so that you could confirm the potential. And I think in 1987, there was a consortium which was led by Petrofina. Petrofina became what? It became another company here. Consortium of three, I think Shell, but led by Petrofina. They tried and attempted to come into Uganda to undertake exploration. And that is the period that the president took a far-sighted decision of sending Ugandan technocrats to hone and buttress their oil and gas expertise. I think in terms of experience and expertise, Uganda is better placed than the region because of that decision which was taken. And some of the senior oil professionals we have on the oil and gas sector in Uganda were part of that batch or thereafter. But the activities could not take off in 1987, 88. And the reason why they could not take off is that that time Uganda and Kenya were on the verge of war. President Moi and President Museveni at that time were not seeing eye to eye. And one of the reasons the oil companies backed off undertaking exploration, they were like, in any case, the pipeline has got to go through Kenya. We do not see, in light of the lingering relationships that the pipeline could go through Kenya. So they backed off. So Uganda kept on doing road trips. Please come to Uganda. We've just come out of a war. We are a good country. We have oil and gas. Come. I think there's, was it Petrofina? I might have mixed up the names. But I think 1993, the guys attempted to come. They signed the PSA. Nothing took off. It was until 1997 that a Good Samaritan came along. And this Good Samaritan was Heritage Oil, which was headed by Tony Buckingham. I hope many of you know what Tony Buckingham used to do. So for him, he had appetite for risk. So when he came to Uganda in 1997, and this is what I usually remind people, when you're evaluating a deal, you look at it from today's perspective, and you do not zoom back in the past to appreciate the historical context. In 1997, we had the ADF war in Western Uganda. Kasese, Bondibujo, those fellows were roaming around. And at that point in time, to get someone to come and partake in an investment, it would be, you'd be out of your wits how you'd come and take that. So that explains why when you look at the early agreements which were signed, they gave away too much. They were much more favorable because that was the mode. That was the mode. You had to give in away too much. Without giving away too much, you would not attract someone to come and partake of exploration in that area where there's insurgency. And that is why I sympathize with Madame Saida Bomba at some point in time when she was being quizzed unfairly by parliamentarians that you signed a bad oil agreement, ABCD, you gave away too much. We were unfair to her. We had not looked back at what had happened back in the past. So the early, Heritage Oil came in, but Heritage Oil was also a bit struggling. So it had to get Energy Africa and Hadman Resources farm out. So of course, at that point in time, no one would even think about taxing the assignment of rights because it would be insanity. This guy is bringing on board other players to come and explore. So when these players came and explored, oil was discovered. When oil was discovered, we were able to attract bigger players. And the subsequent PSAs that were negotiated are much better. They do not have terms that are so favorable compared to the early PSAs, but it can be understood. It's not that these agreements were negotiated in bad faith. These agreements were negotiated responding to the economic circumstances that were happening at the time. And when you speak to some of the logistic players who are involved in moving some of these things, and they tell you stories of how they used to move the rigs, how they would set up tents, how there were bushes wherever they went, how places were so remote, how there were no roads. It's quite an amazing story. But nowadays, you have roads which are being set up in Hoima, Bulisa. The infrastructure has been opened up as a result of this oil and gas discovery and resource, which itself is also significant. And of course, at that point in time, you could not attract someone with very stringent terms if the oil, if there was no infrastructure, if there was no anything that would go for them. So just to guide you, or even to guide myself, while you're answering your question, in case you're privy to some of these documents, or if subsequently you get out these documents, when you're evaluating whether Uganda negotiated well or not, take into account the historical perspective. Do not just focus on the present. And I think that is how things were in the past. Things were much different, and that informs. That is why history keeps evolving, and that evolution informs a lot of the decisions that happen at that point in time. So that is the upstream. Did Uganda get a good deal or not? I would say we have some of the best government officials who really mean well for the country. These government officials were well educated, and whatever they must have agreed upon, whether to give away or not give away, must have been informed by good reasons, some of which could have been the prevailing historical circumstances. So if I find that some of the offers were too good, I wouldn't be so harsh. I would inquire into why did this happen. But more to that, when I see infrastructure coming through, when I see people taking further education, the oil companies supporting and helping people, it's also something around human capital development. When I see the Petroleum Authority requiring that the oil companies and contractors prepare national content plans, which national content plans are supposed to be implemented to the latter around supplier development, around human capital development, that is also a benefit to Uganda as a country. It might be difficult to measure quantitatively, but qualitatively you see that is a benefit for it. Of course, if the oil and gas industry continues to grow and thrive, you would expect that the other players who would come in, their agreements are going to be much more tighter. And if there's also a discovery of oil that is made, the government would be justified to demand for a lot more, because you would come into a country where infrastructure has already been built. You're not going to incur that. Things are easy for you. There's already a pipeline which has been developed. So if clearly the government is asking for a lot more than what they had asked, the tallow oil, they would be justified on the premise of that. Now, getting back to the pipeline, did Uganda get a good deal? As I explained, the pipeline is a necessary evil, because a discovery of oil in itself is insignificant unless if you monetize it. You're going to monetize oil either by having a refinery, either by having a crude oil pipeline through which you're able to convey the oil to markets. Now, the challenges around getting a refinery investor are well documented. Uganda, and that is why when the president spoke on 11th of April, he recounted his history. He said he had said that no oil would ever leave Uganda. He wanted all the oil to be refined in Uganda. They did a lot of surveys. The Foster Whelans of this world came, the Russians came in. When the Russians came in, I remember the then US ambassador was categorical that most likely that will fail because of the sanctions which had been imposed on Russia for attacking Crimea. So that deal fell through. Even at this point in time, they're still trying to do a lot with the AGRC, the Albertine Graben Refinery Consortium, but it still hasn't been unlocked. So that meant that the only way you could fast track Uganda's oil and gas project was building a pipeline. A pipeline is not a project that is aimed at making money. It's not a project. Of course, it will make some money because it has shareholders and it has lenders to it, but ultimately it's meant to unlock oil production. Without the pipeline, you cannot have Bulisa, you cannot have Kingfisher and Tilenga developed. So look at it when you're evaluating whether Uganda did a good deal or not, evaluate it from the perspective that has Uganda managed costs well on the basis of how much is being earned on the ECOP. I would think we've done it well, because at the end of the day, if Uganda was going to impose a lot of taxes on the ECOP, that would build into a project cost. And if that builds into a project costs, it would certainly cascade through upwards to the pipeline to be able to recoup those costs. So I think the Tanzania, and also managing to take it through Tanzania, I mean, that we got it was too good to be true. The late President Magufuli gave us too much. And I think with some people, I think the late Magufuli in 2019, when Uganda and Tanzania were having issues, he had proposed that that pipeline should be named Kaguta Pipeline. But I think with hindsight, it should be named Magufuli Pipeline, because they gave too much, they gave away too much. And then also, it was contradictory. You know? When the late President Magufuli became president, he tightened the investment environment. It was very harsh on the oil companies, and that is why the gas negotiations have stalled. But the way he warmed up to the Uganda project was a total contradiction to what was happening to the investors. You remember the tiff he had with Africa Barrick. He demanded for 100, I think, $80 billion, which was more than the GDP of East Africa combined as taxes. So the fact that we managed to negotiate that, get that deal with Tanzania, we honestly ensure that they're not charging tariff, fees, we got such a good deal. And it's helping preserve the value of the upstream project. And a lot of that value is going to remain locally. Because I think when you do number crunching, when you do an evaluation, I think the government takes over 70%. The entire wealth that is going to be generated by the sector, 70% of that wealth is going to be retained by the government. 30% is going to be taken by the oil companies. Now that is a huge number. I think when we did a comparative calculation based on the model PSAs that are available in public domain, Kenya is a bit lower at maybe 60, but that is understood. Kenya hasn't been very lucky as yet to make as many discoveries. So I think, I mean, if you're able to get over 70%, that is not really a bad deal. Now, in terms of where are we with the project, it's interesting how events have unfolded. You know, a lot of the things that are happening today, tendering, ABCD, usually happen when a formal final investment decision has been called. Now, Uganda, we do not yet have a formal final investment decision. The reason why we do not yet have a formal final investment decision, it's purely formalities. It's just like how shareholders meet. And when shareholders meet in the board, a resolution is passed and that resolution is registered. Now, some of the players within the oil and gas consortium are still going through that process of aligning the internal ABCD. And that internal housekeeping is the reason why you do not have a formal final investment decision. But by and large, from what you see, and also if I take you back to the events of 1st April, when that big event on Sunday, when Patrick Poyen was here, everyone had expected that a final investment decision was going to be announced. But a few days towards there, the messaging started to change. Because if you call it a final investment decision, I think it has repercussions. When you call a final investment decision, some obligations are triggered off in terms of, I mean, what are early activities, the obligations, ABCD. So you're careful not to call it a final investment decision when strictly it isn't, because all the shareholders have got to meet and determine. I think by that time, the back-end, hadn't fully farmed in. Then like the East African Crude Oil Pipeline Company hadn't yet been incorporated. So people were sharing on commitments of taking up shareholding, but you didn't have an entity. That even if Total was running the show, managing all that on behalf of the other joint ventures, strictly speaking and technically speaking, a company that can give out a contract is the East African Crude Oil Pipeline Company. It hadn't yet been set up, but I think it's now been set up. So I think it's more a question of that, but everything that you see happening, the evaluation, tenders happening, these are things that usually happen when a formal FID has been made. So I think because of the delay in the formalities, just formalities, mere formalities, the decision, was taken. The project will go on. That is why for purposes of messaging rights, I think when the government and the oil companies were releasing a communique after April 11th, which communique I understand was heavily negotiated so that you give the right messaging to the world. They called it a project launch. Uganda's launched the oil project, ABC. They didn't call it FID because FID would have repercussions, but everything seems to be moving on. And after that, of course, when you have FID, there's what you call financial closure. So once you've taken a decision, some of the funds have got to be looked for in the market. And I think at this point in time, 60% of the funds for the East African Crude Oil Pipeline is going to be financed. And I think Uganda and the oil companies are at that stage of closing. You know how a deal of this monumental size can take in terms of negotiating with the export credit agencies, the commercial players. The demands are enormous. And I think some of the changes within the laws, ABCD, have all been focused towards that. But I understand that because I think 40% is equity and 60% is debt, even if the financial closure takes a little longer, it can take more than 12 months. to close, the equity, the players can engage some of that early equity for purposes of the project moving ahead. And then as the activities ramp up, that's when the other capital would honestly be, in terms of the debt would be opened up. Then in terms of Ugandan lawyers, I think when you look at Tanzania, their local content regime, I mean, from a selfish point of view, lawyers are ring-fenced services. So all services related, I think lawyers, insurance, banking, they've got to be provided by local players. Of course, at this point in time for legal services, it's not a ring-fenced service. And the reason which was advanced was that we do not have capacity yet, which is true. Some transactions are really complex, but you need to work together with the International Council. But also, as you will appreciate, you in the legal fraternity, when a job is given to legal counsel, he will, in Uganda project, he will deal and manage, but ultimately is going to subcontract most of the Uganda bits to you. So what the final product is usually derived from your end. So you find that if the guy has contracted directly with the oil companies, he probably has $1 million contract. You, because you're so eager to work on this project, whatever they give you, even if it's 10K, you're happy to take with it. After all, you're going to brag that I'm working on this project. So I think as lawyers, we need to come out a little more aggressively and push that legal services are ring-fenced. We're only going to be able to develop capacity if we also subcontract. If Total gives me a requirement to do a complex work, then let it be me to subcontract the BCLPs of this world or the fresh fields of this world to come and work with me on that project. So that way you will be able to grow capacity much better. And then also, we will also be able to command a good number of fees. Of course, there could be challenges around that. Now, you can imagine if you're advising on the pipeline project, because of the critical nature of the advice that you're going to advance, the client is going to ask for an indemnity cover, which is out of this world. The guy could ask for an indemnity cover, which is very significant. So we might have challenges around that, but that is easy, especially if we work together as a society and fraternity, just like how insurance has worked. The oil companies were never keen to have insurance, especially for ECOP insurance originated by Ugandan companies. The Ugandan companies fought tooth and nail, and they indicated that the way oil and gas works is that the peril or risk has got to be insured from where it originates, and then you reinsure. You cannot take all the risks, so you reinsure. So even for oil and gas legal services, if you give me a contract, if I don't have the capacity to do that, I can sublet someone else. If we don't do that, we are going to find a situation whereby, because many of these international players do not know how things operate in Uganda, they're going to contract with their international council where they are. And the international council will look out for Ugandan law firms. And the way sometimes we act and behave is that because we want to get the job, we are too eager, we end up undercutting ourselves. But a job which ordinarily should merit $100,000, it ends up being done at $10,000, which may not be worth it. So I think let's work together. And I think President Fiona Wall, if I recall some time back, I read in the press somewhere, had she hinted, but I think as a society, we need to push a little more aggressive, or else this resource that we've waited and looked for very long, the other guys like insurers who are fighting hard to cater for their interests, they will benefit. But we as lawyers, if we don't also fight hard to ring fence and get what is due to us, we may end up taking crowns. Nicholas?
I'm sure there are so many people listening. Our senior colleagues like Council Kashirinde and the likes, who have an opportunity to talk. I know that our president, Madame Fiona, was very candid. She mentioned that when they met the president as the society, they were able to make sure that those particular recommendations are taken seriously. Thank you so much, Council Dennis Kakembo, Crystal Advocate, a senior tax practitioner, in the High Court of Uganda, and someone who has been involved with the oil and gas legal regime for some good time for sure. And of course, we are very humbled and lucky to have you as one of the members of the Uganda Law Society, and you are willing to share with us some of the techniques of how best we can take advantage of the oil and gas sector as the legal flag.
So much, Nicholas, for that.
So thank you so much, Council. A Q&A coming up just in 10 minutes. But before that, allow me to invite Council Gabriel Chai, if that is how we apologies if I pronounce your name very badly. Council is, of course, is the head at the Uganda Law Society. You be happy to share with us some of the insights as we wait for the Q&A. Council Gabriel, please. Council Gabriel, are you there? Yeah, but still we shall entertain my brother Solomon already asked a question. We shall still entertain more questions as we wait here from Council Gabriel. I think that was a very elaborate discussion. I don't know if I need really to cite out any pointers that Council Dennis really emphasized. It was very elaborate, and I'm sure Council we shall be humbled if you can share with us the slides and your presentation for further reference for our colleagues to follow up with your discussion, which was really very, very important.
I'll share that.
Sure.
Thank you, Council. And of course, it will also be good for me to also pass out some karango, some advert that the Masters of Laws at the Uganda Christian University, which we are offering as well, and of course the Institute of Petroleum Studies. So it would be good for Council to kindly think about also that. I know several senior lawyers have already acquired their knowledge in the oil and gas sector, but learning never stops. So really, UC in particular is offering a good LLM. So it would be good if we all, those who are interested, that is, can think about going for further study, which is very interesting. And as Council mentioned, oil and gas is here to stay. I know we are in the green energy revolution. We are going, all of us are going green, but in my humble opinion, if you have to look at most of the resource-rich we still need oil and gas, and of course our dear minerals for making sure that we get our people from abject poverty. Whereas we want to keep our environment clean, but it would also be important that we utilize our resources to develop, of course, to pass middle income and to maybe first countries. So that is something to also think about. The opportunities which are already flowing. Council was very categorical in telling us that over $15 billion will be invested in this sector. And even the money that, as Council mentioned, that most of the money in the oil and gas sector is sunk in at the initial stage of the development. So it is important for us not to wait, register with the NSD or National Supplier Database, and make sure we take advantage of the opportunities that are available. All right. So we are waiting for Council Gabriel to come in.
Yes, moderator, I'm on. I have been
thank you so
following
much, Council. You're welcome. Please take the floor. Thank you.
All right. I thank you all, dear panelists and the precurrent speakers, for those very able submissions. Indeed, oil and gas for Uganda is what I would like to call a blessing to this country. But nonetheless, I would like to proceed with a segment as directed by Nicholas, just to discuss broadly about the challenges and opportunities that the oil and gas sector presents to this country, and in particular to we, the legal practitioners, and also to share briefly about the SAD project. So in Uganda Law Society, as you all know, under one of our mandates, which is to provide legal aid services through ensuring access to justice for the vulnerable and indigent persons, has a number of projects that run under it. And amongst one of these projects is what we call the Supporting Inclusive Resource Development Project, which is a 5-year project that has been running from 2017 till date. We are in the final phase of our project, and the project is funded by the Global Affairs Canada, which partners with the Canadian Bar Association. The SAD project has 3 project areas. In Uganda, our project area is in Bulisa. We have a project area in Kwale, and we have a project area in Geita at the titanium base, where we are monitoring activities within those different areas. So like I had mentioned, one of our intermediate outcomes is to see that the legal professions and communities are empowered to participate in the oil and gas sector. And we have a keen focus to women and girls that are living within the oil and gas sectors. So we've carried out quite a number of initiatives, amongst them which include, we in 2019 trained 30 lawyers to be policy actors on behalf of the project, and these have engaged really in law reform, and we've been engaging the different communities within Bulisa to participate fully in the oil and gas process. Yeah, so just quickly, I would love to urge advocates to interest themselves in providing their legal expertise in this oil and gas sector. And one thing for certain is that land is a very big factor in the sector, and there are quite a couple of disputes, especially with regard to passage of crude oil pipelines. I have just recently finished a set of 2 activities within Bulisa, one in August and one recently in October, where we were working together with the communities, mostly the project affected persons that are affected by the Tilenga pipeline. And we were coordinating closely with Atacama and Total in providing legal aid for these project affected persons. Now, it is worth noting that there is a very big lacuna when it comes to provision of legal services for these project affected persons within the region. Take an instance, an area like Bulisa has no law firm per se. The nearest lawyers within the region come from Hoima and Masindi. And that there for me is a very big deficit within the sector that as legal practitioners we could probably move to fill. So right now, as we speak, the resettlement the resettlement process is soon coming to a conclusion, and hopefully by the close of this year in December, issues to do with land acquisition will be finalized, and the PAPs will be fully compensated, hopefully at that time. But between now and then, there's quite a lot that lawyers can do in a bid to represent the citizens who are affected by these land acquisition processes. We also see a number of disputes that arise out of compensations. There are quite a number of cases that we did register, and thankfully we have some pro bono advocates within the Albertine Graben that have offered, given themselves to offer a service to represent some of these project affected persons who are affected by the pipeline. So from me, really, I would like to say that there is a very big opportunity for us as lawyers to get into joint ventures within this this sector, and of course, we expect our first barrel to come out in 2022. So I call upon us to get moving, get involved, and get to assist. There's too much that lawyers can do. And one of the major challenges is there is a deficit with the lawyers who are stationed in the area. Like I said, we do not have any lawyer sitting in Bulisa, although we have a court that is not so busy because there are no lawyers to litigate. So I call upon us to pick interest in that area, and perhaps those who can establish branches of their firms there can do so. And I think that will go a long way in ensuring that we involve ourselves more. But also lawyers can involve themselves more with regard to law review and policy briefs. Currently, I'm studying the National Oil and Gas Policy with a group of some colleagues, and we would like to, make some few submissions in that area. But I think it's an area that we can also interest ourselves in as members, and when called upon, perhaps participate and make a contribution in that regard. So, moderator, I see it's already 1 p.m. I do not want to speak too much, but I thank you for this opportunity. Thank you.
Thank you so much, Gabriel. I should be thanking you because I know you're one of the brainchilds behind this. So thank you so much, Gabriel. If you need any more minutes, you can please go ahead, but we should be officially starting our Q&A. I'm not sure whether we have questions as of now, but we should have questions that go to cater for most of all the panelists that have been able to talk to us this morning. So the questions are really welcome. I don't know if you have anything more to add, Councillor Gabriel.
No, I think let's proceed with the Q&A session then.
All right, thank you so much, Councillor. So ladies and gentlemen, kindly jump in if you want. You can any suggestions, because I'm sure people like Gabriel have been listening in since we started in the morning. It has been a wonderful discussion, several discussions we had. So there are some recommendations that have been made, and most notable, of course, the issue of lawyers being able to take charge in offering legal services in the oil and gas sector. So ring-fencing that part of the services, I think, is very important. That shouldn't be taken advantage of, but it's also, I think, incumbent on the lawyers really for us to develop our skill sets, but also, enter into joint ventures, if so, enlarge our our contacts. You know, there are several firms which have connections all over East Africa, and of course, having projects like the ECOP, which traverse beyond borders. I think it would also be paramount for us to get in touch with people from, let's say, Tanzania, and for as we hope to ring fence this important sector so as to benefit the lawyers. So that's very, very important, and many other recommendations and suggestions are welcome. So let's have the Q&A, ladies and gentlemen. Please feel free to unmute or raise your hand. We should be able to pick you up. Thank you. I'm sure our previous panelists are all here. I'm sure Council Dennis is waiting. Council Dennis, are you there?
So let's do this. You go.
Yes, I am. I am.
I don't know if our Council Isaac Christopher Lubogo is still around with us, and Council Andrew Oluka, so that Council can ask any questions. If any colleagues, the floor is yours. Please answer to kindly take on our dear panelists and ask them a few questions, if any. Also, suggestions are welcome. Any submissions, your experiences, you could wish to share any experiences as practicing advocates. If there's anything you have found, any challenges, you know, this is the time to discuss with colleagues of like minds. You know, it would be very important to take advantage of this few minutes or an hour or so. Thank you. Council Solomon Wamai, are you there? Council Solomon, I know you work with the tax appeal tribunal, so you'd want to share with us your experience. For instance, Council Dennis talked about the disputes, which commercial in nature definitely, which are unavoidable in one way or the other, especially in tax. And maybe Council Dennis, there is a tax which was levied on every barrel of oil.
Nicholas, can you hear me?
To go through our pipeline. Maybe you would want also to comment on that. Is it 1.5? Is it $1.7? I don't know. Yes, Solomon.
Yes, Nicholas, can you hear me?
Yes, my brother, please proceed.
Wow, thank you very much. Good afternoon, ladies and gentlemen. I want to thank Brother Dennis for the wonderful presentation he made. Indeed, he has considered so many aspects of oil and gas sector, especially the taxation part of it. And I'm also happy for the question I posed, and he really addressed it. I was very comfortable with the answers and the response he gave. For my case, this is a very good area. You have talked about ring-fencing the good practice in the oil and gas sector. I think as practitioners and lawyers, this is a new area where we have to really do a lot of research, and we put a lot of focus in this area of oil and gas. You know, Uganda being a new frontier in this area, I think there is a lot to be done. We have areas to do with the commissioning. What are we supposed to do in such areas, lawyers? What advice can we give government, and what advice can we give investors who are committing their resources in this area? I think the So from my side, I think this is a very, very good arrangement. I want to thank the Uganda Law Society, especially our president, for organizing this training. We need more of such of these trainings for us as lawyers to share a lot of information and see how we can develop this sector. A lot is needed, honestly. We need to do a lot in order for us to come up with the solid industry as practitioners, and not only practitioners, but even government, especially people who are working with government. They also need to share a lot of synergies about this area. Thank you very much, Nicholas. So far, so good. I'm very, very impressed about this training. Thank you so much. And once again, thank you, Dennis, for your presentation. It was really very, very enriching. Thank you very much. Back to you, Nicholas.
Thank you so much, my brother Solomon Omai, for your candid contribution. Do we have any other hand up? Do we want to have Council Dennis? Yeah, okay.
I'm saying Council Muhege hand is up.
Okay, please.
Are you sure?
George Bamugemerire, please. The floor is yours, please. Can you mute and proceed? Councillor George, are you there? Maybe it was a mistake or something, I don't know. Anyone else who would want to talk to us? With a burning question before Councillor Dennis comes in? Oh, yes. Councillor George Bamugemu, please, admin, could you try and send a notification to Councillor George Bamugemu, unmute. If you just click on his name, normally you can just send a notification for him, either to switch on his video or an audio. Admin, because I don't have my hosting powers anymore.
Let me see. I think, let me see if I do have ask to unmute.
All right.
Thank you very much, Nicholas, and thank you very much, panelists, for this excellent training opportunity. I just wanted to make a little comment about many of the talks that we hear about people preparing to participate in the oil industry. I don't know whether you notice that in many parts of the world, the population is generally indifferent to the activities of oil companies and oil discoveries in their country. One of the reasons why is because this whole and the entire oil exploration and upstream activities are actually require high capital investments. And therefore, oil companies tend to prefer to control the end-to-end process of production of oil, from the prospecting right up to the marketing of the oil, whether in or outside the country. And the reason why they control is because there's a very high cost mistakes. If something goes wrong in oil, either in oil prospecting or oil exploration, the cost is very high. For instance, if there's a spillage of oil in some of the countries where environment really matters, it can be very costly. So that's why they'll be very careful when they are selecting service providers for legal services, for technical services, and so on. They tend to ask for very experienced people whom they already know. And I wanted to put it out there, particularly to the panelists, to make a comment as to how we can take advantage of our virgin industry here in Uganda to see areas where interested service providers can have a role to play in the business. Thank you.
Thank you, Council George, a senior colleague. Thank you so much for that question. I'm sure the panelists are listening. Please, Dennis, do you want to revert? Do you want to react to that?
Yes, I can give a brief response to that.
Thank you.
Thanks, Councilor Gemaire, for that nice and instructive observation. Indeed, I mean, the oil and gas industry is an industry of high standards because of the risks that are associated with it. It's, I recall, I think a few months ago when, like a few years ago, when it was indicated that Uganda would need to get welders, about 5,000 welders from Middle East and far. Our artisans from Katwe could not comprehend and appreciate why this was the case. They were thinking that maybe the government wasn't doing enough to protect, but it's the risks that are associated with it and the high standards, because I understand if there's any burst in the pipeline, the blast can be like a bomb, the bomb blast. So the risks are really high. So what that means is that even as we aspire to find ourselves play a role in the oil and gas industry, we do not have to lose sight of the high standards that are expected in the industry. Even as we demand or as we lobby for affirmative action to see that many local players are given chance to participate, we have to go with something on the table. Creating high standards is a culture. It's not impossible. And for a lawyer, the high standards which would be expected of you by the oil companies would be around the timelines, the training of your staff, which are easy things to achieve as long as you inculcate that culture within your organization. So to inculcate this organization within this culture within your organization, you do not have to wait for an oil and gas opportunity to present itself. You have to start today by taking those small but steady, incremental, progressive actions, which ultimately make that the culture of the firm. Now, how do we grab the opportunities that are available in the sector? These opportunities are not going to find us where we are seated. They're not going to find us in our chambers. We've got to be proactive ourselves by creating relevancy ourselves, not to be ignored by the sector. I already mentioned that the insurance companies were almost being bypassed by the oil companies. The oil companies were saying you do not have capacity to insure these perils, which are very significant. They demonstrated that they could, and even those areas of weaknesses which were highlighted, they put their propositions to the effect that they could easily be able to work on them. So I think even us as lawyers, we can do something like that. Council Achai mentioned something that was very interesting around the work that the Uganda Law Society is doing with Atacama, a new plan, who are helping Total with the resettlement action plans in the oil companies rather than the oil affected regions. Of course, as I mentioned to you, one of the things that keeps the CEOs awake in oil companies, it is no longer the prices. It is no longer about the quality of contractors. It is society issues. Is the community going to rise up? Are we doing everything right to make sure that communities are well taken care of? So already by Uganda Law Society doing what it is doing, providing pro bono services, it is creating the relevancy for it not to be ignored by the oil companies. Because in this era, even if I have the money, I have to create goodwill. I have to have people alongside me that are going to help drum up the message of a project running well, people that have to educate people of their rights so that they can speak confidently and candidly to the oil companies to ensure that their rights are not being trampled upon. With that level of satisfaction, transparency, and openness, the oil and gas sector can thrive. And contrary to what some people might think, that the oil companies are covering up a lot or they don't want to be criticized, this is the level of transparency that the oil companies are clamoring for. Because at the end of that day, if anything goes wrong, if there's any obscurity or opaqueness within the sector, this is something that the civil societies can latch upon, or this is something that financials can easily draw away from. So, I mean, there are many opportunities, and every one of us can play out for what they are best positioned into. Some people within us are businessmen at heart. And a businessman at heart is one who has mastered the technique of buying something for 1 shilling and selling it for 2 shillings. So even oil and gas industry is a business just like any other business. A business where you're going to supply some inputs, some of which are normal inputs, and others are specialized inputs. And if you're a businessman, the challenges you encounter in all other businesses to make your business thrive would be the same. The same techniques you use to make sure that your business succeeds as a law firm by being efficient, ABCD. Even if you venture on a journey of being a supplier in an area of interest, an area where you have so much interest, it is something that you can do. Then there's also the idea of joint ventures. You know, the way joint ventures work, I could have the capital, the social capital, in the sense that I have all the knowledge. I know the right buttons, but I may not be a businessman at heart. I may not even have the capital. But if you're the kind who has the capital, ABCD, you can create collaborations or the social capital, those collaborations with people that have the capital. How can we exploit and monetize this? Because that is at the end of the day, for you to get money as a businessman, you have to be greedy for the money. So you have to think business and come. So the oil and gas industry, let's not imagine that the opportunities which are going to accrue from it about to come, or it's going to be one big bang opportunity. Already, there are people who are working on the oil and gas space. And even then, the oil and gas space is very competitive, but at the end of it all, you can fight in and create your relevancy. That is really difficult to ignore. If you come up with a proposition that can help, it could then be on the policy agenda, policy postulation agenda. If you position yourself as a lawyer who is able to speak to what government needs to hear and what the oil companies are able to hear, or you're in a position whereby you can be such a good arbiter, certainly that is a unique aspect that would be required of you. But then also you would expect that the trickle-down impact of the oil and gas industry, that the economy might grow a bit bigger. So if the economy expands a little bit bigger, even other associated activities or associated businesses would grow. You would also expect, already you can see it, just on the national supply database, there are some thresholds which you must meet from a governance perspective. You need to have a tax clearance certificate. You need to have a registration, which could create room for lawyers. You would also expect that as activities ramp up, these guys, just imagine you're given your a $5 million and you have to go borrow from the bank. You would need to get people that would assist you in that regard. So some opportunities that might accrue, not because of the oil and gas, but because the oil and gas is going to expand the economy. And these are general business opportunities, which today every law firm clamors for. But of course, there's a reason why someone chooses a particular law firm and not the other law firm. So for purposes of positioning ourselves, I think it's a question of ensuring that you position yourself that like that law firm which everyone aspires to go to. What are they doing right? And by doing that right, whether it's oil and gas or non-oil and gas, I think the opportunities would accrue. Then lastly, not quite related to what Councillor George Mugemayire said, but I wanted to make a comment. There's a concern around practitioners about the future of the oil and gas industry. Some people are saying that in this transition to renewables, the oil and gas industry may not actually have a future. Well, there are two distinct schools of thoughts, which of course are to the effect that the oil and gas industry still has a future. So much that if you recall, you remember, was it Texas? Recently, Texas had an issue with its windmills. The windmills froze, and there was a big crisis. Then yesterday, the president wrote an opinion in was it Washington Street Journal, advising that the energy transition, we need to be careful how we move towards that, the energy transition. But even more to that, if you realize now, the oil prices are increasing. And by increasing, Europe and US are suffering energy inflation. And a few months down the road, President Biden, who heads over a faction of progressives who want to drop oil and gas just like that, because of the inflation which was affecting him, he made a comment to the effect that he wishes the oil producers could pump oil a little more. So the journey of energy transition moving away from oil is started, but it doesn't mean that the significance of oil and gas is going to end. What is likely to happen is that the demand for oil and gas is not going to be wiped away, the current demand. What is going to be affected is the level of growth of the increase in demand. If today you are using 100 barrels of crude oil, and because of the increase in population, maybe next year it would be 10% increment in growth, the growth of demand will decrease to maybe 7% because of the alternatives which people are coming up with. But it doesn't mean that oil and gas is going to be done away with. So there's still a future. So don't fear positioning yourself as someone who is building a practice based on oil and gas.
Thank you, Dennis. That's good. Thank you for encouraging us and for that good guidance. Any other person with a hand up? Don't want to leave any stone unturned since we still have like 10 or so minutes. Anyone with a burning question? And any of our panelists who wants to jump in as well? Who's still around with us? Councillor Christopher. Anyone else? Councillor Solomon, your hand is still up. I hope you maybe you just left it. Anyone, members, anyone? Anyone who wants to share their experience so far in the oil and gas practice? Okay. Now, members, it's now 1:30, just a minute to 1:30. If we have no any questions or any submissions on behalf of the Uganda Law Society, who have given me an opportunity to really moderate this session. I want to thank them. And you colleagues, thank you so much for the wonderful opportunity as well. And our dear panelists, thank you so much. We can't thank you enough. In particular, our first panelist, who was from Mwema and Company Advocates, Council Andrew Oluka, took us through intellectual property rights, protection as an enabler, local content in the oil and gas sector. Thank you so much, Council Andrew. And our Lord Don Council Isaac Christopher Lubogo, thank you so much for also a thorough analysis of the need to legislate gas emissions in Uganda, in Uganda's oil and gas sector. And of course, our council from Crystal Advocates and the managing director of Crystal Advocates, our tax consultant and advocate of the High Court of Uganda, Council Dennis Kakembo. Thank you so much for giving us enough time today. And of course, the deep analysis of the oil and gas sector, which you really very well know right away from its inception. And of course, the historical background you shared with us, of course, the current timelines and so on. I think that was very helpful for all of us that attended this session. And of course, apologies from Council Emmanuel Muwonge, who was unable to attend, or from Katende Simple and Company Advocates, who was supposed to take us through financing of oil and gas structures and how lawyers would basically participate. Hopefully we shall look at that the next time. And of course, to the President of Uganda Law Society and the organizers from the Uganda Law Society team, thank you so much. And everyone, if there is no any communication from the Uganda Law Society, then we can definitely able to end this session until next time. Thank you so much, ladies and gentlemen. God bless.
Good afternoon, dear membership. Thank you so much. I can't thank you enough for being a part of this oil and gas, virtual CLE training. I want to thank so much our facilitators, our speakers for the day. I want to thank Dennis Kakembo. I want to thank Mr. Oluka and Mr. Christopher Luvogo. And to thank so much our moderator for the day, Mr. Mhereza. Thank you so much for your insights also. They were so, giving us a lot of knowledge and your input in that. We thank Gabriel also, who was able to share from the Uganda Law Society. And thank you so much for being a part of this. We're definitely going to share the presentations that we have received from our speakers on your emails. That will be later, once we compile all the presentations that we have, and we'll be able to share them with you on email. We take this opportunity to thank you so much. Those who haven't yet accumulated their CLE hours, we want to encourage you to attend the upcoming CLE events so that you're not caught up, and by the end of the year, you have the minimum requisite CLE hours, which are 20. I thank you so much, and I wish you a great afternoon. Thank you.